matter. I filed it on 27th, my lord. It may come up on Friday.
Right.
Similar prayer, admission matter.
Admission matter. Admission
Monthly by the
1 week later.
next Monday. Pensionary benefit matter.
Pensionary benefit 12th. 12 hours.
Well, yesterday I have filed a writ petition challenging the negligent validity of a my lord appointment of a college teacher of Cotton University. And without declaring the result, my lord, appointment letter was issued, my lord. And my lord, he is supposed to join today, my lord.
So we can't give you unlisted today. Friday.
And otherwise, my lord,
If he joins, he joins. It will be subject to outcome of the writ petition. You are challenging the appointment.
and without declaring the results, my lord.
I mean, but you'll have to array that person also as a party.
But
If you can ensure that you are going to serve advance notice, then it's a different issue. Will you serve?
if he joined, my lord, then my lord,
If he joins, the college cannot be without a professor. If he joins, it will be subject to outcome of the writ petition.
this is the matter, my lord. My lord, they have
Mr. Counsel, supposing we interfere with it, can we direct you to be appointed instead? No, it goes for a fresh selection.
tomorrow,
Friday.
Friday, tomorrow, my lord.
You have difficulty, you make alternative arrangement. Tomorrow is not a motion day. You have it on 10th. If you have difficulty on Friday on 10th.
Friday.
Right.
May I please?
Evening.
I'm praying for listing one matter WPC for admission loss on Friday or Monday loss.
19th.
19.
I beg to mention the list of petition for admission column. Pension.
19th.
Therefore, listing the metro's last posting 6/12/24.
6/12/24. 19th.
Before 15 immediate.
Why?
Because my senior.
Your senior is not there, you make alternative arrangements. From December, you and your senior did not find time to list the matter till August. Now you want it before 15th. We will direct listing in December 26. Let it be listed in December 26. All right, December 26. You have it on 19th or on 17th?
19.
19th.
Listing to requisition for admission category.
19th. 19th.
Letters may be taken up along with item number 9. Admission similar.
Item 9.
9.
What is item 9?
9. 9.
The issues are similar, but
Ah.
matters are in orders function.
Hold on. 9 all over 1. You want these matters to be called up with 9 or you want 9 to be called up?
No, your lordship should be taken up along with 9.
Along with 9. 9 all over 1.
Okay.
Yes.
Service pension, madam. Instruction, yes.
Here, madam, some report has been seeking from the office of the secretary, from the director, madam. That has been yet to madam provide by the director to the secretary.
What are you praying for? Service pension?
Pension, my lord. Pay your pension, service pension. From 2019, my lord.
No affidavit filed.
My
We
lord,
have filed our
same stamp they have taken, my.
What is the stand?
My lord,
Yeah,
ad hoc period of the service of not counted for the pensionary bill. Same stand taken in the affidavit.
You were working on ad hoc.
Prior, my appointment was ad hoc. I have completed 28 years.
How many years in ad hoc?
28 years, but duly sanctioned post in a government basic school.
So you are working as an ad hoc
Ad hoc.
or in a government school, not regularized, not provincialized.
Time to time, ad hoc appointment was extended until further order, my lord. My appointment was duly sanctioned post. And similar situated person availing same benefit, my lord. Page number in my writ petition, my lord. Page number 56.
56. Yes.
In the column, second, depend borrower, first name, my lord. Is also similar situated person, and his order is in page number 55.
He was regularized. Why have you
By
not?
giving ex facto post approval.
Why not? Why is it not regularized?
Here, my lord, we have filed our affidavit, my lord. The affidavit.
In their affidavit, my lord, they have taken same stand. The impugn order,
Yes.
they have stated that ad hoc period will not count for pensionary benefit, and in their affidavit, they have taken same stand.
No, is there a particular reason why the teacher is not
Not specifically stated in the affidavit.
then?
Well, here, may I raise it?
You are already retired from service.
My lord, in 2019, 31/7/2019. From 2019, now 26, my lord. Not only the Dilip, my lord, Dipen Borwa, Dilip Gayan also availing same benefit by giving ex facto post approval.
This kind of notification, office memorandum report has been sought from the director.
So this, on as per the memorandum, she is entitled.
Well, that has been reflect from the. Some time may be granted, my lord, because this report has been asking from the director by the secretary, my lord. Let the report may.
When do you want the report? When can you have the report?
It will be, my lord, after 2 weeks, my lord.
My lord, from 2024, they have taken time for that.
No, my lord,
No, get it next week. Next week.
10 days,
Next week,
my lord, 10 days, I'm paying.
heard counsel for the parties. The name of the writ petitioner is for grant of pension and arrear pension for her services rendered as a what?
Assistant teacher,
Assistant teacher
Uyapara,
in what school is it?
my lord, Uyapara, government basic school.
Viyapara.
Time to time, she
Government
was
junior basic
transferred, my lord.
And
So-
ultimately, rendering services for as many as 28 years and finally demitted, superannuated in her capacity as assistant teacher in Miyapara Government Junior Basic School under the office of the Deputy Inspector of Tejpur. Grievance of the petitioner is that notwithstanding her service that she has rendered, she was not regularized and she continued to render her service on ad hoc basis, although other similarly situated persons were also rendering services on ad hoc basis, came to be regularized and are now enjoying the pension for the services rendered. Counsel for the petitioner has referred to an order dated 28/10/2016 to show that by which order the district elementary education officer had approved the financial upgradation of the teacher's name therein. Name of the petitioner appears at serial number 3. Another relevant point in time, she was a teacher in Sotial Gaon Government Junior Basic School, and persons at serial number 1 and 2 were also working as ad hoc teachers, subsequently came to be regularized by order dated 20th of September 2018 and are therefore enjoying the pensionary benefits, while same benefits have been denied to the petition. Person in serial 1 and 1. The learned government council submits that the affidavit has been filed by the department, and it is the stand of the department that because the petitioner was not regularized, he has not been allowed her pensionary benefits. So the learned government council, during the course of the argument, has fairly referred to an office memorandum dated 12th of September 1996, issued by the government of Assam, Department of Pension and Public Grievances, which specifies that persons who had rendered temporary service of not less than 20 years without being confirmed in any way are to be allowed pensionary benefits as available to a retiring confirmed government employee, either on attaining the age of superannuation or on his being declared to be permanently incapacitated for further government service by the appropriate medical authority. Stop. The learned government advocate submits that in this context, the report has been called for from the director.
Yes, Madam.
Which report is awaited. He therefore prays for 10 days time. There are considering the submissions made and the OM dated 12th of September 1996, this court considers it appropriate to have the matter listed again on 12th of August, by which time the respondents may place before the court any instructions they may have received. Mr. B. Chakraborty appears for Accountant General. Release this matter on 12th.
Bless.
You go and urge all this before the arbitrator.
Lordship, the issue is
The issue is limitation.
limitation, and they have issued the section 21 notice merely after 4 years.
Whatever it may be, all these you take it up before the tribunals.
But your lordship, the
We'll
judgment,
permit you to urge everything before the tribunal.
but your lordship, there are judgments which says, I'll place reliance on the judgment of this court only.
No, it says that there is where not necessary, you need not refer. But there are greater number of judgments to say that the referral court is only to see the existence of the agreement. If it is there, send it to the tribunal.
But your
Supreme Court judgments.
these are also Supreme Court judgment. There is the Nortel networks, which
Later Supreme Court judgments.
that's there, your lordship.
So
But-
therefore, the whole purpose is there is no. It is not in dispute that there is an agreement. It is not in dispute that certain differences are very simple. The question is whether these differences now can be addressed in view of the law relating to limitation and the procedures being followed. This requires detailed examination, which can be done by the tribunal. So far as the court is concerned, if we examine the materials, we find that yes, there is an arbitration agreement. Parties have agreed. There is a dispute, apparently. Like hypothetically, for instance, the agreement is very specific that you have fixed number of disputes which can be referred. And the dispute on which the referral is sought for is prima facie a dispute not included in that list. Then suddenly there is no point in referring. So the question of whether the tribunal should exercise jurisdiction, whether it is arbitrable or not, the purpose of arbitration is to not relegate the parties to the civil court. It's alternative dispute.
But at the same time, your lordship, while referring to the arbitration, if the test is conducted to see whether the claim vis-a-vis which the arbitration is sought is actually expressly time barred. Otherwise, we both the parties will suffer into an long-term and an expensive arbitration proceedings.
You had agreed to it.
We had
On a day when you entered into arbitration, you knew it's bound to incur some expenses.
that is there, your lordship. I'm not disputing that. But the section 21 notice should have come within the period of 3 years. That has come after
That is
4
what we are
years.
saying, that why should the referral court get into all this aspect and decide whether it was time barred, whether it is there or not. All this can be left to be decided, urged before the tribunal
On the maintainability issue.
on the maintainability issue. If the tribunal finds that yes, you are correct, it's not maintainable, matter ends there. Unless you dispute that no, there is no arbitration agreement. Or this arbitration agreement was superseded by subsequent agreement where the parties agreed, or there is no dispute at all. Whatever they are claiming, you have already settled, no dispute. So on the technical issue of time bar, that too during the COVID period.
Your Lordship, the COVID is not applicable to that. COVID benefit is not applicable because the judgment is very clear. Because Your Lordship, section 21 is something which is between the parties of a contract. Where there is
So
an
we are saying,
arbitration
see,
clause.
we are only going by the law laid down by the apex court that generally don't go beyond an examination to see whether there's a valid arbitration agreement, which is there.
No, I'm not on that right now. I'm on the point that they are taking the benefit. They are trying to draw a benefit of the Supreme Court judgment vis-a-vis the COVID period.
So your only objection to not go before a tribunal is expenses, right? There's no other hardship that you're going to face,
I'm already a loss-making company.
whatever it may be.
I'm suffering.
But fortunately, unfortunately, you agreed to arbitration.
Yes, that's
Now, let us say that arbitration was not there. What was the only alternative? Civil court.
civil court.
You both, being trial court lawyers, you know the degree of expenses. We need not go beyond. So therefore, once there is an agreement that yes, there is an arbitration, you should go by that agreement. You raise all questions, maintainability, everything before the tribunal. The tribunal finds that yes, you're correct, they'll pass it on.
Also, my objections may be recorded.
Yes, we'll record.
Can you
your
record my objections?
So, we can go for a hearing now. But I was thinking that the whole purpose of this court is a referral court. We are not deciding on the list between the two parties. We are not deciding whether there is or is not a dispute, whether you have a better claim, he has a better claim. We are only trying to see whether this matter can be sent to
arbitration.
an alternative dispute resolution to resolve the dispute. Now, if the whole purpose of hearing the matter is to decide that, we might as well resolve the dispute. The amount of time that we'll spend.
Yes.
But we are restrained from doing it because we are only a referral court. So therefore, I was suggesting that if you agree, we nominate an arbitrator, you decide all matters, maintainability, everything. Let the arbitrator decide this. Yes. Is there any judgment you want to place in support of your contention that?
Yes, I am having. One is of this court only, JCL Infra.
Justice Michael's judgment.
Yes, which discusses
But there are subsequent apex court judgments
which
after
again
that.
further discusses as to what the referral court is to do with an
Exactly.
arbitration.
Right.
I'm placing it on record. I place reliance on the Supreme Court judgment for the COVID period and for other judgments supporting my contentions.
So let us, the COVID, we leave it aside. What is this next judgment? BNTAG?
Yes. Your Lordship, this judgment at para 52. At 52.
Yeah.
The following two questions fell for the consideration of this court in Norton Networks. The period of limitation for filing an application under Section 11 of the 1996 Act and whether the court may decline to make the reference under Section 11 where the claims are ex facie time barred. This court in Norton Networks observed that the 1996 Act has been framed for expeditious resolution of disputes and various provisions have been incorporated in the 1996 Act to ensure that the arbitral proceedings are conducted in a time-bound manner. The 1996 Act does not prescribe any time period for filing an application under Section 11(6). Since there is no provision under Section 11, one would have to take recourse to the 1963 Act as per the Section 43 of the 1996 Act, which provides that the Limitation Act shall apply to arbitrators as it applies to proceedings in court. Since none of the articles in Schedule of Limitation Act provides a time period for filing an application for appointment of arbitrator under Section 11, it would be covered by the residual provision under Article 137 of the Limitation Act, which provides that the period of limitation is 3 years for any application for which no period of limitation is provided elsewhere in the division. The time limit starts from the period when the right to apply accrues. Now, in the judgment of JCL Infra at page 6, para 11 of my copy, the copy I have provided.
Of the judgment.
Yes, JCL Infra.
JCL Infra.
Yes. page number 6, para number 11. It discusses BNTAG.
You have provided Vidya rule, yeah?
No, there's another bunch.
Yes.
ACL Infra, page 6, para number 11. It discusses BNTAG versus Ministry of Defense. And further, it at the last paragraph, if your lordship may have.
Yes.
The Supreme Court in the above case has held that there is a fine distinction between the plea that the claim received is barred by limitation and the plea that the application for appointment of arbitrator is barred by limitation. It has held that even if the arbitration clause contains a provision that no cause of action shall accrue in respect of any matter agreed to be referred to until an award is made, time still runs from the normal date when the cause of action would have accrued if there had been no arbitration clause. Thus, the claim for arbitration must be raised as soon as the cause for arbitration arises, as in the case of cause of action that arises in a civil action. Section 43(1) of the Arbitration Act states that the Limitation Act 1963 shall apply to arbitration
So
as
all
it
these
applies
are,
to.
see, for instance, Arif Aziz is referred here, but Arif Aziz
Yes.
lays down the law that the referral court's intervention should be minimal.
That's
Right.
I'm not disputing that.
So therefore, what we are trying to understand is you have a valid ground for objection, subject to a satisfaction that yes, limitation does apply, and beyond that, claims cannot be raised. It is not a case where the dispute arose 10 years back and thereafter the petitioner woke up and decided to refer matters for arbitration. It is not a case that the claims raised, dispute arose, but nevertheless the company continued to perform their duties together. And after several years, turn around and say, okay, this dispute arose. It's not a case like that.
Right.
It's a case where whether the limitation would be from this date or from this particular date. So under these circumstances, I think as a referral court, it is best to be left to be decided by the arbitral tribunal. If we have to get into this, we can get into it. But in view of the overwhelming Supreme Court judgments, the interference is required to be minimal. Yes.
Yes. But I had also prepared a compilation of judgment.
All right, if you want.
No,
judgments,
I'm not for a moment suggesting that, Your Lordship, because ultimately, my lord, it's the eye of the needle scrutiny. That's the phrase that has been used. So, therefore, unless and until it's expressly barred by limitation, which is not the case, because ultimately they have also admitted that 80% have completed. There has been no termination of the contract so far. In fact, in my last notice, which I had sent in 2023, that is when I invoked the termination. So, termination expenses, whether the cause of action would actually begin from the date of invoices, whether it will begin from termination, all those questions would require minute examination of the terms and conditions. So that exercise, in my respectful understanding, cannot be undertaken at this stage, at the reference stage. Well, the issue of limitation will in any case be left
There.
to.
what do you say with regard to Nortel and BNT?
In fact, Nortel, I would have relied on the paragraph which supports me because it made a distinction. So far as limitation to prefer section 11 is concerned, that of course this court will examine. So far as the other question is there, in fact, I may just paragraph 15, 16, make it clear, Norton's statute. That is where they've discussed the tribunal versus claim test also.
Yes. Which paragraph?
Para 15 onwards. That's where they've drawn the distinction between the two aspects of limitation.
Get down like.
That, of course, my friend has also considered that these are two different aspects of limitation. Then from para 40 onwards, if your lordship sees.
Yes.
The issue of limitation in essence goes to the maintainability or admissibility of the claim, which is to be decided by the arbitral tribunal, as your lordship found. For instance, a challenge that a claim is time barred or prohibited until some precondition is fulfilled is a challenge to the admissibility of that claim and not a challenge to the jurisdiction of the arbitrator to decide the claim itself. In Swissboro Diamond Mines versus Kingdom of Lesotho, the Supreme Court of Appeal distinguished between jurisdiction and admissibility in para 207 and 208, which read as jurisdiction is commonly defined to refer to the power of the tribunal to hear a case, whereas admissibility refers to whether it is appropriate for the tribunal to hear it. Waste Management INC versus United Mexico States to this Zachary Douglas adds clarity to this discussion by referring to jurisdiction as a concept that deals with the existence of adjudicating power of an arbitral tribunal and to admissibility as a concept dealing with the exercise of the power and the suitability of the claim brought pursuant to that power of adjudication. So and so at para 291 and 310. The conceptual distinction between jurisdiction and admissibility is not merely an exercise in linguistic hygiene pursuant to a pedantic hair-splitting endeavor. The distinction has significant practical import in investment treaty arbitration because of a decision of the tribunal in respect of jurisdiction is reviewable by the supervisory court at the seat of the arbitration for or before an ICSID ad hoc committee pursuant to Article 50 of the 52 of the Convention, whereas a decision of the tribunal on admissibility is not reviewable. Just see so and so jurisdiction and admissibility in global reflections on international law, commerce, and dispute resolution. Then, if your lordship sees para 42, the judgment in Lesotho was followed in BBA versus BAZ, wherein the Court of Appeal held that the statutory time bars go towards admissibility. The court held that the tribunal versus claim test should be applied for purposes of distinguishing whether an issue goes towards jurisdiction or admissibility. The tribunal versus claim test asks whether the objection is targeted at the tribunal in the sense that the claim should not be arbitrated due to defect in or omission to consent to arbitration, or at the claim in that the claim itself is defective and should not be raised at all. Applying the tribunal versus claim test, a statutory plea of statutory time bar goes towards admissibility as it attacks the claim. It makes no difference whether the applicable statute of limitation is classified as substantive, extinguishing the claim, or procedural, barring the remedy in the private international law sense. The issue of limitation which concerns admissibility of the claim must be decided by the arbitral tribunal either as a preliminary issue or at the final stage after evidence is led by the parties. So, my lord, if I have understood it correctly, to say that the tribunal should not even venture into that question would be a objection to jurisdiction, but to say that the claim itself is not admissible would be a test of admissibility. Insofar as the latter is concerned, that has to be reserved for the tribunal. So limitation generally would fall in the latter category.
No, what about arbitrability of the issues? Are you suggesting that limitation and arbitrability
Yes.
fall into different arenas? Arbitrability
Arbitrable?
of the issues
Yes. Yes.
is one aspect,
Yes.
and the other is notwithstanding the arbitrability of the issues. there is a question of limitation.
Yeah.
So are you saying that these are separate issues and one is left to be decided by the referral court, the other?
No, I'm saying this admissibility part limitation would eventually attack the admissibility of the claim. The moment it is an objection to limitation, in other words, it is an attack to the admissibility of the claim, which is the domain of the arbitrator.
Or are you saying that admissibility and arbitrability are two different things?
Yes, yes. Because arbitrability should perhaps means the test of jurisdiction.
Would you come back to the paragraphs again?
Yes, yes. Para 40 on.
This BNT.
Yes. Para 38 onwards. The same judgment. If your lordship sees the previous two paragraphs, then probably can give more clarity.
36 onward.
38. Limitation is normally a mixed question of law and a question of fact and law.
So you are reading from which judgment?
The same judgment.
Which is?
Not it. BSNL versus.
Nortel is not here.
I have provided a copy.
You have?
I have provided a copy.
Yes, yes.
But the pages may not tally.
Ah.
It's a difference.
Yes.
Para 38, Honor. Your lordship finds running page numbers at the bottom, page number 32 of that compilation.
Yes.
Issue of limitation. Your lordship found it?
Para 38.
38.
Yes.
Issue of limitation. Limitation is normally a mixed question of fact and law and would lie within the domain of the arbitral tribunal. There is, however, a distinction between jurisdictional and admissibility issues. An issue of jurisdiction pertains to the power and authority of the arbitrators to hear and decide a case. Jurisdictional issues include objections to the competence of the arbitrator or tribunal to hear a dispute such as lack of consent or a dispute falling outside the scope of the arbitration agreement. Issues with respect to existence, scope, and validity of arbitration agreement are invariably regarded as jurisdictional issues, since these issues pertain to the jurisdiction of the tribunal. Admissibility issues, however, relate to procedural requirements such as a breach of pre-arbitration requirement, for instance, a mandatory requirement for mediation before the commencement of the arbitration, or challenge to a claim or part of the claim being either time-barred or prohibited until some precondition has been fulfilled. Admissibility relates to the nature of the claim or the circumstances connected therewith, and admissibility issue is not a challenge to the jurisdiction of the arbitrator to decide the claim. So exactly what your lordship was suggesting, that the objection is not that the tribunal cannot decide the question of limitation. So it's a question of admissibility rather than of jurisdiction, and therefore, while in this reference stage, Manoj, the scope of inquiry would be only confined to the aspect whether the section 11 petition is on time or not, rather than whether the claim is time barred or not, because that would essentially be a claim regarding I mean an objection regarding admissibility of the claim. Manoj, following judgment, Manoj, that's the NTPC judgment. Running page 58, if your lordship has. 50, yes, running page 58. At the bottom, Manoj, the eye of the needle.
Yes.
The above referred precedence crystallizes the position of law that the pre-referral jurisdiction of the court under 11(6) of the Act is very narrow and inheres two inquiries. The primary inquiry is about the existence and validity of an arbitration agreement, which also includes an inquiry as to the parties to the agreement and applicants' privity to the said agreement. These are matters which require a thorough examination of the referral court. The secondary inquiry that may arise at the reference stage itself is with respect to non-arbitrability of the dispute. As a general rule and principle, the arbitral tribunal is the preferred first authority to determine and decide all questions of non-arbitrability. An exception to the rule, and rarely as a demurrer, the referral court may reject claims which are manifestly and ex facie non-arbitrable. Explaining the position flowing from the principles laid down in Vidya Drolia, this court in a subsequent decision in Nortel so and so. While exercising jurisdiction under section 11 as the judicial forum, the court may exercise prima facie test to screen and knock down ex facie, meritless, frivolous, and dishonest litigation. Limited jurisdiction of the court would ensure expeditious and efficient disposal at the referral stage. At the referral stage, the court can interfere only when it is manifest that the claims are ex facie, time barred, and dead, or there is no subsisting dispute. The standard of scrutiny to examine the non-arbitrability of a claim is only prima facie. Referral court must not undertake a full review of the contested facts. They must only be confined to a primary first review and let facts speak for themselves. This also requires the court to examine whether the assertion on arbitrability is bona fide or not. The prima facie scrutiny of the facts must lead to a clear conclusion. There is not even a vestige of doubt that the claim is non-arbitrable. On the other hand, if there is the slightest doubt, the rule is to refer the dispute to arbitration. The limited scrutiny through the eye of the needle is necessary and compelling. It is intertwined with the duty of the referral court to protect the parties from being forced to arbitrate when the matter is demonstrably non-arbitrable. It has been termed as legitimate interference to refuse reference in order to prevent wastage, so and so, so and so. Now, my lord, again, this was the jurisdiction and admissibility test was reaffirmed.
Here the interpretation is otherwise.
Barring, my lord, here it says if there is even a single doubt whether my claim would.
No, but
The last part, the last part.
the jurisdiction
Yes.
at the referral stage
Yes.
is only when it is manifest that the claims are expressly time bound.
Yes. That exception is there. That exception is there. But it says to see whether it is expressly time barred or not. Then if there should be no vestige of doubt that it is actually time barred. And if there is even an iota of doubt, that question will be left open for the arbitrator to decide. Subject to correction, this is what I've understood.
So therefore,
Yes.
your argument that jurisdiction and admissibility are different and time
Barred
limitation falls under admissibility entirely.
No, that limited exception is there. In fact, Arif Hazim also says that, and I concede to that. It's not as if. Now, if your lordship sees again, running page 109, this is the relevant portion of Arif Hazim. Here again, they have reaffirmed that limitation would fall into that other bracket of admissibility.
What about the other? There are judgments before Arif, like SBI General Insurance and
SBI General Insurance is after Arif probably. That's the
Is it?
last
Okay.
judgment.
No. Then after that, there are a few other judgments.
SBI is there in that compilation.
But SBI is on the school of minimal interference.
Yes. In fact, even SBI and Nortel, Arif Hazim also said that there is an exception, but that's a rarity. And so does NTPC.
There's another one recent judgment. One is Gogi Technologies.
That.
Subsequent to that, another judgment. Anyway, now tell us on the facts.
Otherwise, it was a construction agreement. Page 17, your lordship finds the agreement. This was for construction of an administrative residential dormitory and certain shop buildings at Mongol Road.
17.
Page 17 is the main agreement. Here, of course, the arbitration clause is not figuring, but if your lordship sees page 19, it says the GCC would govern the relationship. That's clause 1.2b.
There is no arbitration agreement here.
Here, no, it is in the general conditions of contract. That is at page 117. 101.
You have brought it by way of the additional level.
Yes.
101.
Yes.
Yes.
4.16.
By two arbitrators.
We've nominated ours, Manoj. The dispute otherwise is pertaining to delay, Manoj. While we say that the delay was attributable to them because we've been exchanging letters since 2016.
Where is your 21 notice?
21 notice, your lordship finds page 65 is the first letter. Twenty-three 9/23. Here, of course, there's one at page 66. There was a blank. Our instruction was that the copy included the name. Anyways, that was reiterated at page 67 again with the nomination.
Now, when was the work order issued?
Work order was issued on 29th March 2016. That's the agreement.
29 March
2016.
That's the work order.
That's the agreement.
So that page?
Page 17, Manoj. LOA, your lordship finds at page 16, the previous page.
This is LOA is dated?
5/3/2016.
Then
My lord, throughout 2016, lordship will find certain letters were addressed from page 33 onwards, citing hindrances on the site and non-delivery of site. The works, however, continued wherever the site was accessible, and they have admitted that we've completed 80%.
Then,
Then, my lord, throughout 2016, 17, and 18, various letters were issued, and we kept on raising invoices, but the payments were not forthcoming. And ultimately, there was a minutes of meeting held on 5th of September 2018, my lord. That is at page 60, my lord. And there we requested in that minutes of meeting to release the payments of
Wait.
the.
This is dated
This is dated 5th of September 2018.
page number 60.
60.
Yes. What was the outcome?
My lord, no payments were received. In fact, they noted that we must submit a work schedule, and there were counter allegations in the form of emails from page 61 onwards. And that is the time we made it clear that without clearance of the RA bills, we will not be able to continue with the work. Page 62 is that particular email. Finally, at page 65, Manoj issued the first request, and page 67 is the second request. Now, in these emails, that is how Manoj, they seek to draw the point of limitation. In these emails of 2020, that is at page 64, we were referring to 3 RA bills primarily. So those RA bills are of the year 2018. So they want to suggest that the cause of action would accrue in 2018. However, my lord, these RA bills may not be the only cause of action, because the the contract was never terminated, and it is only when we found that to continue further would not be possible, we terminated it in the year 2024.
Is there a provision that you can terminate?
No, there's no termination. There is no termination.
So it was, literally speaking, abandoned.
My lord, I'll still call it termination, given that the contract act would give me the right to say that it's now become voidable because of impossibility. Because unless you give me site and payment, I cannot complete the work. Because site was their responsibility and obligation under the contract.
No RA bills was released.
No RA.
Not a single bill.
Not a single.
RA1 was released.
RA1.
RA1 was released.
Oh, I'm sorry. Out of these were second, third, and fourth.
except one bill.
RA1 is not in dispute.
Now, these three bills are second, third, and fourth.
No. RA, except RA1, the rest of the bills have not been released.
Not.
And we have received only one RA2, one bill duly certified from the site engineer.
Page 196, your lordship will find their response to the RA bill.
What was the contract about?
For construction of an administrative block, dormitory, and shop rooms.
Where?
In
Mongol
Bazaar, Mongol.
So these running bills were for what if the site was never handed over?
But we continue, site was not available in certain areas, but we have completed 80% as an admission on record. And bills were not due. Of course, there are counter allegations that I was short of manpower, etc.
Where is that admission of 80%?
Page 201, para 6.
Then
Third.
665 is your 21 notice.
Yes. Followed by 67, the second. In fact, my lord, I had pointed out the earlier hearing that if your lordship goes by the calculation of limitation from those RA bills, then also if COVID extension is afforded to me, I am within time. And in fact, it is available to. In fact, Supreme Court has applied that in the case of offshore. Page 197 is how they want to calculate.
197.
197. They've given a table.
So how do you overcome this by the judgment of the apex court in COVID?
Yes. But will I have that annex to the compilation also?
One. Yes.
Lord has the compilation page 141, or your lordship may take up the last order, which sums it up at page 152.
Yes.
March 2020, this court took suo motu cognizance of the difficulties that may be faced by the litigants in filing petitions, applications, suits, appeals, all other quasi-judicial proceedings within the period of limitation prescribed under general law or any special laws, both central and or and or state, due to the outbreak of COVID-19 pandemic. So it's broad enough to include everything within its scope. On 23/3/2020, this court directed extension of the period of limitation in all proceedings before the court's tribunals, including this court, with effect from 15/3/2020 till further orders. On 8/3/2021, the order dated 23/3/2020 was brought to an end, permitting the relaxation of the period of limitation between 15/3/2020 and 14/3/2021. While doing so, it was made clear that the period of limitation would start from 15/3/2021. Thereafter, due to the second surge in COVID-19, the Supreme Court's Advocates Association on record intervened in the suo motu proceedings by filing the miscellaneous application seeking restoration of the order dated 23/3/2020, relaxing limitation. The aforesaid miscellaneous application was disposed of by this court with the order dated 23/9/2021, wherein this court extended the period of limitation in all proceedings before courts or tribunals, including this court, with effect from 15/3/2020 till 2/10/2021. The present miscellaneous application has been filed by the Supreme Court Advocates on Record Association in the context of the spread of the new variant of COVID-19 and the drastic surge in the number of COVID cases across the country. Considering the prevailing conditions, the applicants are seeking the following. I'll skip that. The directions are at paragraph 5. The order dated number 1. Taking into consideration the arguments advanced by the Learned Council and the impact of surge of the virus on public health and adversities faced by litigants in the prevailing conditions, we deem it appropriate to dispose so and so with the following direction. The order dated 23/3/2020 is restored, and in continuation of the subsequent orders dated 8/3/2021, 27/4/2021, and 23/9/2021, it is directed that the period from 15/3/2020 till 28/2/2022 shall stand excluded for the purpose of limitation as may be prescribed under any general or special laws in respect of all judicial or quasi-judicial proceedings. Consequently, the balance period remaining as on 3/10/2021, if any, shall become available with effect from 1/3/2020. So the deadline, the limit has been stretched. Now, 3 is important. In cases where limitations would have expired during the period between 15/3/2020 till 28/2/2022, notwithstanding the actual balance period of limitation remaining, all persons shall have a limitation period of 90 days from 1/3/2022. In the event the actual balance period of limitation remaining with effect from 1/3/2022 is greater than 90 days, that longer period shall apply. It is further clarified that the period from 15/3/2020 till 28/2/2022 shall also stand excluded in computing the periods prescribed under Section 23(4) and 29A of the Arbitration and Conciliation Act, Section 12A of the Commercial Courts Act, and proviso B and C of Section 138 Negotiable Instruments Act 1881, and any other law which prescribe period of limitation for which instituting proceedings, outer limits within which the court or tribunal can condone delay and termination of proceedings. Perhaps on the last occasion, my friend had relied on Roman 4 to suggest that so far as arbitration is concerned, it's only 23(4) and 29A that is applicable. However, reading of the entire order would show that this has been specified in addition. That's why the language shall also stand excluded. And the rest of the paragraphs is clear that all judicial and quasi-judicial proceedings shall get that exemption. Now, RA2, of course, there's some dispute. RA3, for example, just to take one instance, Manoj, RA3 was 19/7/2018 as per that table in page 197.
Yes.
19/7/2018 is when the cause of action, according to them, accrues. Now, this limitation continues to run till 15/3/2020. So by till 15/3/20,
According to the table, it is 18/7/21.
19,
19/7/18
19/7/18.
is the date of payment due.
So that is according to them, the cause of action arises
Right.
then.
And it will continue till
Till 15/3/2020, untouched, because COVID is not there. So by till 15th,
No, how will it be 15/3? It will be, as per their dates, it is 18/7/21.
yes. That's what. Now, my lord, para Roman 3 is clear
Oh,
that where the limit. Okay, now let us take their date, 18/7/2021.
right.
Now that is within that COVID period.
So according to you, it will extend to 28/2/22
No, after that I will get another balance.
of 90 days.
No, more than that. Because whichever is larger, I'll get. If I may read 3 once again.
So you are saying this.
I have consumed nearly about a little short of 2 years.
So 18/7, according to you, 18/7/21, it falls between 15/3/20 and 28/2/22. So therefore, your 3 years will count from 28, 29 or 1st of March 2022.
Actually not, but I'll get lesser than that because it says notwithstanding the actual balance period of limitation remaining, all the persons shall have a limitation period of 90 days from 1/3/2022. Then this is important, the latter part. In the event the actual balance period remaining with effect from 1/3/2022 is greater than 90 days, the longer period shall apply.
So therefore, that's what we are trying to understand.
Yes.
1/3/2020, it expires according to them on 18/7/21.
Yeah.
But 18/7
Is
within the
that
period.
bracket.
So it will continue till 28/2/22.
And from that day, the balance period. Now, how do we calculate the balance? Well, we'll have the second column, 19/7/2018. Now, 19/7 to 15/3/2022, I have consumed 21 months because it is a little less than 2 years. So, remaining 1 year and 3 months is the balance period that I will be entitled from 28 to 2022 as per the last part of Roman 3.
You have to give it us in a tabular form.
So, Manoj, if I
But
get
this will have to be, you are reading it in respect of the general provisions of limitation. You are saying that this is applicable to all cases.
all cases. Why have they mentioned 29A is because 29A sets a deadline for completion of the proceedings. So does 23(4) for completion of pleading. So they deemed it appropriate to specify that those time periods will also not be counted. They didn't, of course, say anything about 21 because 21 is in any case is not providing for a time limit. And in fact, offshore's judgment, they've taken note of this COVID.
Your Lordship may, if I may
Go on.
submit.
Let us, we'll come back to you. Offshore judgments.
Yeah. That's at page 127.
127. What was the issue there?
The same, Manoj, that cause of
Limitation.
action accrued within period of within that COVID period. Para 22. This is at page 133. para 22. In the present case, the final bill was raised by the appellant on 23/3/2018, and the amount became due on 21/4/2018. That is 30 days from the date of submission of the bill. Likewise, as submitted by the appellant. The period of limitation to file
Your payment as per the contract is 30 days.
30 days.
30 days from the date of
Yes, sir.
certification.
Certificate. All right.
Now, it would start from 21/4/2018, and an application ought to be filed within three years from such date. However, the appellant has filed the arbitration case number so and so before the High Court on 15/3/2022, which is beyond 3 years. In the normal case, the application filed by appellant would have been hit by the statutory bar of 3 years. However, it is essential to refer to the order of 10/1/2022 of this court in re so and so, wherein a 3-judge bench of the court has held that in view of COVID-19 pandemic period from 15/3/2020 till 28/2/2022 shall stand excluded for the purpose of limitation as may be prescribed under any general or special laws in respect of all judicial and quasi-judicial proceedings. Then that order was quoted, para 24 thereafter. The above decision came to be delivered by this court considering the hardship faced by the people during COVID-19. It would be unjust and detrimental not consider this while deciding upon period of limitation in present case. Therefore, the benefit of the period of so and so must be given to the appellant, and this period need to be excluded while counting the period of limitation for filing application for appointment of arbitrator. Once this period is excluded, it can be concluded. That's all. So this COVID has been extended to a case for appointment of an arbitrator also, madam. And even otherwise, the order is clear. It is all encompassing. And what I need to show going by NTPC is merely a vestige. There should be no doubt. I mean, no vestige. There should not be any iota of doubt that it's barred by limitation. Now, perhaps considering all of this, and my claim tomorrow can be multifarious. I can also claim termination expenses, voidability, compensation for voidability. Now, to strictly confine it only to the RA bills may also not be proper at this stage. So, therefore, since there is another way of looking at things that where my claim may not be barred by limitation, this question should be left to the tribunal. At least from the eye of the needle of scrutiny, it doesn't seem to be ex facie time barred.
Yes.
Your Lordship, at first, let me correct one fact that they have submitted. They are saying that we have admitted that their work is completed to 80%. And to take back to Your Lordship to that particular paragraph at page 201, para 6 of my counter.
Para 6.
Para 6, page 201. Here, Your Lordship, I have mentioned about the completion of project site. It is not related to the entire project site is 80% complete, wherein they were supposed to construct the dormitory and other housing facilities, which they have not done.
So you are saying that in the project side, there are other contractors also there.
Yes, yes.
So insofar as the
Overall.
entire project site, it is 80%.
Yes, 80%. And this agitation we are taking up with the Ministry of Textiles also, where we are seeking the funds because it's a special project.
So far as the completion of the petitioner, what is the extent?
They have only completed work till RA number 1, to which we have paid. Thereafter, there are.
Is it there anywhere in your affidavit?
I have mentioned it in my page 196, para number 3, where I am objecting to the ingredients of RA number 2, 3, and 4. There were certain serious deviations from the standards of NIT. That is why we have not considered RA number 2 specifically, and RA number 3 and 4 is not as per the terms of NIT.
Yes.
Para number 3, towards the last side, it is submitted at page number 196, Your Lordship. It is submitted by the deponent that the invoices bills bearing RA2 dated so and so was received and booked by the respondent upon due certification of the engineer in charge at project site. However, the invoices of bills being RA3 dated so and so and RA4 dated so and so were not booked by the respondent on account of defective supply and commissioning along with serious deviations in contractual terms and conditions as per the governing NIT at the end of the petition. The deponent also states that no GST upon the alleged invoices of bills so raised upon the respondent company has been paid or deposited with the treasury by the petitioner as mandated under the strict GST regime. Now, my side of facts is that when the RA2 was raised and we have certified, we found that there were serious deviations. There were complaints, there were whistleblowing amongst the petitioner's company itself, which raised an alarm for the respondent.
So RA bill was rejected, or
We have not cleared that RA2 bill because subsequent works were not as per the terms of NIT and there was serious deviation. For example, if we required 24 mm of TMT bars, they were using 12 mm of TMT bars. We raised this issue before the petitioner, but no heed was paid. Only remedy left to us is to withhold the payment of RA number 2. RA number 3 and 4 is not in question because it has not been certified and further the deviations were there.
okay.
Now coming back to the limitation point, Your Lordship, on the facts, I have given a table at 197 page of my counter
Yes.
and I have mentioned the due date of payment, that is the date of cause of action when it arises and the date when the cause of action ends. Now, on the RA2, the last date of cause of action was 24th April 2021. On this date, the alleged RA3 and RA number 4 was also raised. So according to me, 24th April 2021, on this or any date prior to this, they should have raised or issued the section 21 notice.
No, that is, there is no dispute on that. According to them, that was in the middle of COVID, so therefore
I'll come back to it.
they
I'll
are
come
relying on
I'll
facts.
come back to that. Now, they have not raised that, they have not issued the section 21 notice on or before 24th of April 2021. Why I say so? Because on 24th April 2021, RA number 2, RA number 3, RA number 4 was already on record of the petitioner and it was raised according to them. So if we count the last day of RA number 2, the last day of cause of action, then it is well within that cause of action, they should have issued the section 21 notice, which they have not done. Now, the alibi that they have taken is that they are well within the ambit of COVID-19 judgment. Now, Your Lordship may kindly have the COVID-19 order, 10th of January 2022.
Yes.
Page number 4, 3 and Roman 3 and Roman 4. I'll read it together.
You're reading from?
My copy here.
All right. Order
Order dated 10th January 2020.
10 January.
Yes, there's
10 January, yes.
5 pages. Page number 4, Roman para 3. In cases where limitation would have expired during the period between 15/3/2020 till 28/2/2022, notwithstanding the actual balance period of limitation remaining, all persons shall have a limitation period of 90 days from 1/3/2022. In the event the actual balance period of limitation remaining with effect from 1/3/2022 is greater than 90 days, that longer period shall apply, which is their contention. My contention is at para number 4. It is further clarified that the period from 15/3/2020 till 28/2/2022 shall also stand excluded in computing the period prescribed under section 23(4) and 29A of the Arbitration Act, section 12A of the Commercial Courts Act, and proviso B and C of the section 138 of the NI Act. So, Your Lordship, in my limited understanding, if I apply the adjustum generis rule here, it excludes the specific provision of these 3 acts, and only the limitation benefit is given to these sections or the provisions of these 3 acts. It specifies that rest are not included. Anyhow, a logical argument is that section 21 notice is between the parties to a contract. Court has nothing to do. Court will only come on the date when the notice was served and the respondent has failed to act or has negated to act. Only thereafter the court will come. Till then, it is between the parties. Yeah.
You are saying that 3 and 4 are not to be read together. Yes.
Now, since they have not issued within the limitation of 3 years, the section 21 notice, now we come back to the judgment of Norton.
Judgment of
Norton, BSNL Norton
Norton.
Networks. My copy, Your Lordship, it's a direct order copy. Page 22, para 36. Para 36. In a recent judgment delivered by a three-judge bench in Vidya Jolia on the scope and power of Section 8 and Section 11, it has been held that the court must undertake a primary first review to weed out manifestly ex face, non-existent, and invalid arbitration agreements or non-arbitrable disputes. The prima facie review at the reference stage is to cut the deadwood, where dismissal is barefaced and pellucid, and when on the facts and law, the litigation must stop at the first stage itself. Only when the court is certain that no valid arbitration agreement exists or that subject matter is not arbitrable, that reference may be refused. Now, in para 144 of the court observed that the judgment in Mayavati trading had rightly held that the judgment in Patel engineering had been legislatively overruled. Para 144 read as observed earlier, Patel Engineering Limited explains and holds that Section 8 and 11 are complementary in nature as both relate to reference to arbitration. Section 8 applies when judicial proceeding is pending and an application is filed for stay of judicial proceedings and for reference to arbitration. Amendments to Section 8 by Act 3 of the 2016 have not been omitted. Section 11 covers the situation where the parties approach a court for appointment of an arbitrator. The Mayavati Trading Private Limited, in our humble opinion, rightly holds that Patel Engineering has been legislatively overruled and hence would not apply even post omission of subsection 6A of the section 11 of the Arbitration Act. Mayavati has elaborated upon the object and purpose and history of the amendment to section 11 with reference to subsection 6A to elucidate that the section as originally enacted was facsimile with Article 11 of the Unilateral Model of Law of Arbitration on which the Arbitration Act was drafted and enacted. While exercising jurisdiction under Section 11 as the judicial forum, the court may exercise the prima facie test to screen down and knock down ex facie, meritless, frivolous, and dishonest litigation. Now, my submission is this litigation, present litigation, is ex facie meritless because they have not approached or instituted the Section 21 notice well within the period of 3 years. And at page 65 in their arbitration notice, they themselves have mentioned, may your lordship may kindly have page 65 of the arbitration petition. Page 65. The arbitration, section 21 notice.
Just a minute. Yes.
Page 65, the middle of the page, it is their notice, section 21 notice. It has been nearly been 4 years ever since the submissions of the RA bills. In the arbitration notice, they themselves are mentioning and admitting that it has already clocked
Page
page 65.
65.
Your Lordship, the middle of the page, first paragraph only.
It's been 4 years,
Yes.
nearly 4 years.
It has been nearly 4 years ever since the submission of the RA bills and the certification by the concerned site engineer, but no payment is seen forthcoming from your end. So they themselves are admitting that it is a time-barred claim. Moreover, there is a misrepresented fact that all the RA bills have been certified by the site engineer.
But factually, you'll have to point out. Actually, these RA bills are, how many RA bills? 4 or 5?
Three.
Three RA bills. So on this date, all the 3 RA bills were raised.
I have given the respective dates at page 197 of my count.
197 only refers to 2.
No. 2, 3, and 4. 197 and 198. The tabular representation.
197. (197) is RA2.
And thereafter RA3.
RA3.
And at 198 RA4.
What about RA1? That is paid.
RA1 is not in dispute. We have cleared that. And there is no other further RA bills after RA4.
Yes.
So, Your Lordship, they have not, they themselves are admitting that it's a time-barred claim in that arbitration notice itself. So, Your Lordship, the rule of cutting down the dead wood is applicable in this instance case while exercising section 11 jurisdictional power.
Subject to the interpretation of the COVID
Yes.
Supreme Court judgment. You will have to elaborate on ejus dem generis if you want to rely on that to say that only 4 is applicable.
Sure.
Because there's one area which has been pointed out to say there is further clarified to mean that beyond the general proposition, it's also clarified that in these particular sections, because there is a specific time limit, that also gets extended.
But Your Lordship, my submission is the court will only interfere when there is failure to appoint an arbitrator on the dates given in the arbitration notice or any other terms of contract.
See, I'm just thinking aloud for the benefit of the bar. The core issue, had there been not the COVID order, it would have been a time-barred claim, ex officio. Had there been no COVID order, that COVID order now has been laid down to at least in one paragraph, it says in all cases, it shall be extended beyond this. The other one, it also extends the time limit given in particular sections in the arbitration and the other acts. So therefore, your interpretation is that so far as the order is concerned, it is only applicable in para 4, nothing beyond. Contrary to the submission of the counsel to the petitioner, that it applies en masse to all if para 3 is to be read. So, you have to address us on this concept that only in these matters, only para 4 is to be read specifically, excluding para 3 and the others, when they are all part of the same order. It's a part of the same order. Will you, this court appreciates the arguments coming from the clerk. So if you want, we'll give you convenient date to
Yes. I'm
elaborate on
satisfied
this
with
argument.
on this point.
Elaborate on this argument.
Sure.
Since you have already made a reference, might as well argue on this and
Yes.
yes.
Well, para 4 actually is not concerning limitation at all. But if we go to the Limitation Act, what is Limitation Act saying? Limitation Act is saying the burden is on the party to approach or apply within a particular time. It applies for suits, appeals, and application. Now that is already covered under Roman 1 and 2 and Roman 1 and 2. Now Roman 4 was added because though it doesn't concern limitation, 29A is not concerning limitation. That is not the duty cast upon the litigant to approach within the time. It's a time limit set for the court. So over and above the relaxation of limitation laws which apply to a litigant, the time limit prescribed for the court was also enlarged, which is why it finds specific mention in para 4. Otherwise, for limitation purposes, 1, 2, and 3 is what covers it.
Yes.
Because 29A, 23(4) is not concerning limitation. It's time limit for the court or the tribunal to complete. And what is limitation is there in the Limitation Act, the first section, bar of limitation. What is a bar of limitation? When a litigant should apply or prefer a suit, institute an appeal within a particular period of time. So the Honorable Supreme Court in its wisdom thought that we should not only relax limitation for the litigants, but we must also enlarge time limit for the tribunals. And one is, like your Lordship, en masse, it says all proceedings. And then, my lord, even if COVID is not, it could, for all we know, it could be a continuing breach of contract also. Very fresh period of limitation, because the contract continued, my lord, nobody terminated. So therefore, under section 27 of the Limitation Act,
You are concerned with only the bills which are early
no,
raised.
my lord, I eventually, ultimately, bills is one part of my.
That's right. But now in terms of your 21 notice,
Yeah, my lord, if your lordship sees the 21 notice also, my lord,
you are essentially
67.
concerned with the RA bills. You are not claiming damages or anything like that in
No,
terms of
if
the
your
agreement.
lordship sees page 67,
So termination.
68, more specific.
Huh? What is it?
68 for a moment. Because until this, I did not terminate. Your company has been solely responsible in preventing the undersigned from carrying out the works. You have failed to perform your reciprocal obligation, and as such, the contract amongst the parties has become voidable at the option of the undersigned. The undersigned therefore issues this notice of termination. The contract between the parties, including the agreement, shall accordingly stand terminated. You are hence requested to settle.
Just a passing thought. You have been awarded the contract.
Right.
You do not abandon it. You continue. There was no claim by them for cost, imposition of cost or anything. So, ordinarily you are entitled to raise your claims in respect of works
Already done.
already done.
And also loss of profit, my lord.
And loss of profit. But
So-
instead you terminate the contract.
Yes, because after post termination, if we go by the general rules of contract, if the termination has occasion because of voidability, because of a breach of a particular condition by the owner, Manoj, then besides over and above the bills, I'm also entitled to termination expenses, liquid, maybe actual damages, loss of profit.
So this will have to be first raised. You'll have to put the employer to notice.
So, Manoj, the agreement, unlike other railway contracts, etc., it doesn't require that I must submit a claim. The arbitration clause is very simple. At the moment there's a dispute, it goes to the arbitrator.
Correct.
So therefore, there's no requirement of pre-submission of claims, etc. So I can reserve all my claims.
No,
to
no.
be-
If you are saying that no, this 2024 is we have abandoned the earlier notice and 24 is the notice under
No, Manoj,
21.
I have not abandoned. Manoj, what I did was earlier, since that was an ongoing dispute, I shot that notice and I said, please appoint an arbitrator. Next time I again send another notice, you've not complied with my demands, I have no other choice but to terminate it, and I reiterate my request for appointment of an arbitrator. Now, after I terminated,
Yes.
after I terminated, over and above the unpaid bills, my lord, I may be entitled to damages compensation. Because ultimately, if I am right that you are responsible for the contract being rendered voidable, then you are liable to pay me damages, my lord. Now, if your lordship has section 27 for a moment of the Limitation Act,
Yes.
today they have come up with allegation my work was substandard, etc., my lord. In fact, I have annexed those publications where they have described me as an efficient contractor. Anyway, my lord, they did not terminate the contract. The work went on, maybe at a slower pace. The RA bills were not cleared, my lord. They did not give us the site, the proper access to the site. So all of this would fall in my respect. Another view of looking at things is it may fall within what is known as the a continuing breach, my lord. Section 22 for a moment, if your lordship has, of the Limitation Act. Because they had a continuing obligation. They did not do it within time, and it continued, that breach continued throughout, my lord, until I terminated. Because until I terminate, the contract subsists. And they are therefore under a continuous duty to
Yes. Section
22.
Yes.
But continuing breaches and torts. In the case of a continuing breach of contract or in the case of a continuing tort, a fresh period of limitation begins to run at every moment of the time during which the breach or the tort, as the case may be, continues. So therefore,
So essentially what you are arguing is that the page 65 notice,
yes,
although it was premised on section 21, essentially page 67 notice supersedes the earlier notice.
it doesn't. It doesn't, because 21 doesn't say that it should come, because unless the terms of the contract specify, 21 request doesn't speak of any form. Neither do I
It
have
does
to.
not. What I'm saying is it your argument to submit in view of the objections raised on the ground of limitation that this 21 notice which were served on 25, yes, page 65,
Yes.
even assuming it is accepted to be barred by limitation, then 67 notice is still there.
No, not exactly, my lord, because 65, page 65 notice also, I may have raised the grievance that ultimately my bills have remained unpaid for four years. Therefore, you let us arbitrate and resolve it. There, I did not really specify my claim that in that future arbitration that will commence pursuant to your agreement, I will raise such and such claims, because I'm not required to do that. Now, that request was not complied with. Then, my lord, I went as far as terminating the contract. Until that time, the contract subsisted because they did not terminate, although they may say my work was substandard, etc. So after it terminates, my lord,
So why we are asking you is because your 21 notice is only with regard to RA Bill 2, 3 and 4.
my lord, 21 notice is my
Essentially, that
my
your
lord,
bills have
20
been not paid, etc., etc. There is
Yes.
no other claim raised.
my lord,
Because if you into 21,
yes. 21 says request, just a request. '21, if I may read. Unless otherwise agreed by the parties, the arbitral tribunal in respect of a particular dispute commences on the date on which a request for that dispute to be referred to arbitration is received by the respondent.
Correct.
So it's only a request. Now the dispute is that contractual dispute. It can have various facets, my lord, which I may not necessarily elaborate in my request. And so therefore, my lord, what my future claims are going to be can be adjudged today that since I have mentioned only about RA bills in that request, my claim is confined to RA bills alone, and therefore there has to be a mathematical calculation, precise calculation from the date when the bill became due.
you're right. Yes. We'll keep it on 11. If there's any further thing you want to submit. Or there could be some queries from the court.
No.
11,
13.
13. Can it be 13?
13.
Can be. There are some matters fixed already.
Or any other date?
All right, let it be 13. Let us. 13. Mr. B.D. Decker. The Commissioner, Mr. Chaudhary. Teacher. P. Chaudhary. Respondents. The parties have addressed the court. The reason, however, the hearing will be conclusive. For the hearing on 13th August is agreed to by the council.
Deeply honored.
আৰু এইখন one respondent because step on scan. Yes, ইয়াতকে ডাঙৰ কি আছে yes.
Matter pertains to minor pro rata pension and GPF with interest and leave encashment matter. The petitioner was initially appointed as a assistant professor of the Dibrugarh University minor. Perceive kindly see the running page 14 minor, date of appointment minor. Thereafter, minor at that point of time, while the petitioner was appointed as a assistant professor minor, at that point of time there was no provision of the pensionary benefit, and his service was governed by the CPF scheme. Subsequently, my lord, the Dibrugarh University has been amended the Dibrugarh University Amendment Act 2013 and introduced for the first time the pensionary benefit to their employees of the university. And lordship, and subsequently the executive councils of the university drafted the Dibrugarh University Pension Rules 2013. So Lordship, kindly see the running page 19. my lord. So my lord, may I read my? Yes, ma'am. The first of all, my lord, Lordship, kindly see running page 18, my lord. Sorry for application of the rules. Yes, ma'am. The permanent employees of the university, both teachings and non-teaching, who have entered service before 1/2/2005 shall be eligible for pension on their retirement from the service of the university with effect from 1/4/2013. Provided that the employees of the university who entered service before 1/2/2005 and who have retired or expired before coming into force of this rule shall be entitled to receive pension or family pension as the case may be under the provision of this rules. Now, Lordship, kindly turn the next page, that is running page 19. That is 4B, Lordship, kindly see. The matter
You
of,
entered service when? When were you appointed?
I appointed 1/4/2004.
1/4/2004.
Yes,
Yes.
yes. So, Lordship, kindly see the 4B, my lord. The matter of granting eligibility of pension under this rule shall be guided by the Assam Service Pension Rules 1969 wherever applicable.
And
Now-
what has happened after that?
After that, my lord, the petitioner has been applied to the Cotton University. At that point of time, the Cotton College. And subsequently, the Dibrugarh University has been issued no objection certificate. And the petitioner applied the extraordinary leave without with me and my lord. Subsequently, he tendered his resignation letter before the Dibrugarh University. And the same was placed before the executive councils of the university. And his resignation letter became effective, my lord. Subsequently, within the 6 months period, my lord, the petitioner, Lordship, kindly see the representation 59, running page, my lord.
Yes.
Yes, my lord. May I read, my lord? I would like to inform that I was an assistant professor, so and so.
No, what is the period you entered service on 2004? You tendered resignation on
on 2018.
2018.
Yes, my lord. That is the next page, Lordship.
14 years. 14 years.
Now, 11 years, 6
Huh?
months, 10 days I have completed.
2004 you entered.
Yes, my lord.
You resigned on 2018.
Yes,
How is it 11 years?
my lord. My resignation letter was became effective, Lordship. I just kindly see, my lord. That was running page 58, my lord.
58.
58.
You were on lien.
Yeah.
Thousand 17 you have tendered.
Yes.
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 Then
Now, Lordship, now the moot question here is that, Lordship, whether the petitioner relief, the pro rata pension or lump sum amount will cover under the Dibrugarh University Amendment Act and read with under the Assam Service Pension Rules 1969 or not. This is the question. Last of the my lord, this question was raised by the learned senior my lord, by the respondent side. So my humble submission before your lordship, with all due respect, I have categorically stated in my affidavit in reply, my lord. Now, lordship, kindly see my affidavit in reply, my lord. That was running case, my lord. 133. So I just briefly stated, humbly submitted with all due respect, my lord. So the 2013, the Dibrugarh University Amendment Act is a subsequent act, my lord.
where is the Amendment Act?
Amendment Act was annexed by the, my lord, the respondent in running case, lordship, kindly for a moment.
That was Lordship in running page 85, man, the Dibrugarh University Amendment.
What does it provide?
It provides that new section has been incorporated, that is 30A. The same I have already read, my lord. The permanent employees of the university, both teachings and non-teaching, who have entered service before 1 to 2005, and the petitioner has been entered in the year 2004, my lord, shall be eligible pension on their retirement from the services of the university with effect from first day of April 2013. Provided that the employees of the university who entered into service before 1 to 2006 and have retired expired before the force of this act shall be entitled to receive pension or family pension, or as the case may be, or the provision of this act. Provided further that, so the, my lord, the relevant portion, lordship kindly see, the 30A2 subsection provides that the university shall regulate the matter regarding the implementation and payment of pension, family pension to their employees, such authority of the university as may be determined by the university. Provided that the matter of granting and eligibility shall be guided by the Assam Service Pension rules.
This you have already referred to, page 18.
Yes, my lord.
This is the rule.
Yes.
Ah.
So, my lord, my humble submission before your lordship is that the 1969 rules is an earlier act, and the Dibrugarh University Amendment Act 2013 and subsequent act, and this is called as legislation by reference, man. So these, if any amendment made to the earlier act, those will automatically apply to the.
No, what exactly are you trying to say?
Yeah,
What do you want?
Now I file an application before the university to pray for, my lord,
The pension,
release my pro rata pension.
pro rata pension.
Pro rata pension.
So they have refused to do so.
Yes, my lord, exactly.
So what has that got to do with the Assam Pension Services Act? Services Pension Act?
90 and the rules 98 provides the basic criteria for the
What,
granting
98 rules?
of the Assam Service Pension rules.
98 rules.
Yes, ma'am.
What rules?
Assam Service Pension Rules 1969, Rules 98.
Rule 98.
Rule 98.
Oh, say that. Rule 98.
Rule 98.
What is Rule 98?
So that provided the basic criteria for granting.
Rule 98.
Rule.
Yes, tell us.
So the
Read Rule 98.
my lord, the book is not.
And your book is not with you. You are referring to Rule 98.
So the
What is Rule 98?
I have categorically stated in my additional affidavit the basic criteria, my lord. What is the essential ingredients? The petitioner has already fulfilled that essential ingredients, my lord.
Yeah, Mr. Gogoi.
Case is totally different, Lordship. So Lordship may kindly period case 86, Lordship.
86.
86 is a part of the amendment act, Lordship.
Yes.
It's a 2013 amendment. Starts from page 85. My lord may kindly directly come to 3, Lordship. Sub-rule 3, 30 and sub-rule 3, Lordship.
Yes.
Pension under this section shall include superannuation pension and family pension only, Lordship. Does not include gratuity, Lordship.
Right.
So, Lordship, that particular amendment was done in 2013, Lordship. That includes only, Lordship, superannuation pension and family pension, Lordship. Here, petitioner is resigned from the service on, Lordship, 18. Probably, Lordship, the resignation was submitted on 18, Lordship. That was done. And he was under the CPF scheme. So, my lord may kindly page paragraph 3 of our affidavit, Lordship, page 76, Lordship.
Oh, is he not covered by these amendment?
No,
rules?
Lordship, he is not covered by the amendment. He is not superannuated from the service,
No,
Lordship.
that will come later.
Yes,
First,
sir.
he entered service prior to 1 to 2005.
Prior to 1 to 2003, Lordship, 1 to 2005, Lordship.
There is no dispute.
There is no dispute, Lordship.
Right.
That part will be
But
applicable.
he resigned.
He resigned. That part will be applicable when the person should be superannuated, then he will get the pension, Lordship. And if he is died, Lordship, that family pension, Lordship. He is under the CPF scheme, Lordship, and all the CPF amount he was given, he was returned, Lordship. So, my lord may kindly come to page 76, paragraph 6, Lordship. And gratuity amount also he was returned, Lordship. Even CPF, Lordship, more than that amount he was returned, Lordship.
76,
76 paragraph 6 Lordship, in our affidavit.
para 6.
Para 6 Lordship. That with regard to the statement made in paragraph 3 of the writ petition, the answering deponent herein states that at the time of appointment of the writ petitioner in the year 2004, the service of the petitioner was governed by the Dibrugarh University's Contributory Provident Fund Benefit Scheme Lordship. The General Provident Fund GPF cum pension scheme was not applicable to the service category of the petitioner at the time of his appointment. It is stated that only after amendment of Dibrugarh University Act in the year 2013, so and so had adopted the GPF cum pension scheme to govern the service of all the permanent employees of the university, both teaching and non-teaching. Then my lord may kindly come to paragraph 9, page 77 Lordship.
Yes.
That with regard to the statement made in paragraph so and so Lordship, the ensuing deponent admits the fact that the writ petitioner had tendered his resignation on 7/12/2017. However, the deponent herein clarified that section 20 of the Dibrugarh University Act does not deal with the resignation. In fact, the entire Dibrugarh University Act 1965 does not contain any provisions regarding resignation as stated by the petitioner in the instant paragraph. This further stated that the Act do not contain any provision for acceptance of processing of consequence resignation of the employee Lordship. So then my lord may kindly come to paragraph 11. It's stated regarding the financial benefit which was given to the petitioner. That with regard to this,
From where do you say that the CPF was adopted after the amendment?
before amendment CPF,
Huh?
at the relevant point of time when petitioner is appointed Lordship, the CPF scheme was there Lordship.
CPF scheme.
CPF scheme was there.
So this amendment was also took place during the currency of the petitioner's service.
Petitioner currency of the petitioner service, but he resigned from the service.
No, that is the only objection.
That is the
but
only
otherwise he is eligible.
if he is continuing Lordship,
Huh.
continuing, then he will covered by the pension scheme.
Right.
There is no dispute Lordship. Even Lordship,
Now this superannuation pension, what is the meaning of superannuation
that the
pension?
persons who has retired from the completing the age of retirement, is 60 years Lordship, he should be retired Lordship, then he will get.
This is not contributory pension.
No Lordship.
This is under the old rules.
It's a regular pension Lordship.
It's under the old rules.
It's a regular pension Lordship. He is under the CPF scheme, all the contribution, even the contribution which is from the university side also Lordship, given the even access
Was it indicated in the
paragraph 11 Lordship, we have
executive body meeting or whatever meeting by the
paragraph 11 my lord may kindly. Paragraph 11.
of the university while accepting? Paragraph 11 of
Paragraph 11 of our affidavit, page 78. Lordship,
yes.
petitioner has already been I start from third line Lordship. Petitioner has already been paid the admissible gratuity amount of so and so by voucher on so and so until the date of effect of his resignation Lordship.
No,
And
gratuity already you have given him.
Given. Even Lordship, CPF amount also we have given. Next page I will come. Then my lord may continue. It is stated that the amount assessed and determined by the life insurance corporation.
Is there any authority you're relying on to show that this superannuation will mean that a person will have to retire? And if there is a resignation or
Resignation
reduction,
is a technical resignation, is a continuing the service of the Cotton College.
that's right.
He cannot get a two pensions simultaneously. He cannot get a two
Or
pensions.
pro rata.
That part Lordship, I will come.
Pro
Yes,
rata
because
will be
pro rata,
applicable.
if he is entitled for pro rata pension
This is a
Lordship,
Cotton University will not give him pension from 2000.
Lordship we
13.
will give the pro rata pension subject to refund the amount Lordship. All the CPF, his contribution already is taken Lordship.
That
Yes,
from
yes,
where are you saying
Lordship,
that?
I am
both
saying from
come-
our
come
document.
together?
Lordship, kindly peruse the documents Lordship. Peruse the statement Lordship.
No, statement has to be based on some
It is a
office
relevant
memorandum rules.
Lordship.
This
It
is a statement.
it is a basic principles of service law that when CPF, GPF and pensions are totally defined component Lordship. It's not a single component Lordship.
You enlighten the court.
That part I rely on judgment of the Honorable Supreme
Yes,
Court.
yes, please.
Before that Lordship, what amount he have get, just I explain it.
So that we have seen at
Lost.
para 11, you have stated CPF, whatever amount you have got.
CPF he has even Lordship more than the amount he has taken Lordship.
But supposing he would have superannuated,
Then Lordship, if in case of superannuation, CPF my amount will be converted to the pensioner amount Lordship. It will not refund to the petitioner Lordship. GPF is not refund to the petitioner Lordship.
Now, my lord, with all due respect, my lord.
Yes.
May I submit, my lord, one? Now,
Sir,
Lordship,
sir.
kindly come 102, my lord. Running this for a moment, my lord, with all due respect.
Why for a moment? We'll be there as long as you want.
Then Lordship, he has finished, then I will start. He can finish his case, Lordship. I will
Yes.
start.
My lord, Lordship, kindly see the appointment letter of the petitioner, my lord. Point 1, Lordship, kindly see, my lord. His service will be governed by the Dibrugarh University Teacher Service Conditions Ordinance 1974. Now, Lordship, I have relied one point.
No, we have understood all
Yes,
this. You show us that these amounts are separate and he is entitled to this amount.
Yes,
On
my
what basis?
Lordship, kindly, I have already stated running page 137, paragraph number 12 of my affidavit in reply.
Your reply affidavit is irrelevant.
Because, my lord, they have calculated only the year 2015, but I have tendered my resignation in the year 2018. my lord.
Their objection is that having paid the CPF, you are not entitled to pension.
No, that is incorrect submission.
Incorrect on what basis? Tell us.
Correct on the basis because, my lord, the amendment of the Dibrugarh University 2013 provides that the pension means superannuation pension and, my lord, the family pension, and it
All right,
excludes
we have heard you.
retirement.
We have heard you. Take your seat. Yes, Mr. Gugoi.
So Lordship, that regarding GPF and CPF, Lordship. Wait, so talk. My lord may directly come to internal page 354, Lordship.
354.
Lordship.
Yes.
33.1, Lordship. The difference between CPF and GPF was always in existence and as held by the constitutional bench in the court in Lordship, Krishna Kumar case, Lordship, and the rules governing the provident fund in its contribution would entirely differ from the rules governing the pension scheme. Lordship. Then my lord may 45, Lordship. 45, Lordship, 360, Lordship.
45.
45, Lordship. Where Nakara's case was discussed, Lordship, the distinction between two schemes was dealt with the paragraph 32 of the decision of so-and-so, Lordship. 32, Nakara, it was never held that both the pension retirees and the PF retirees form a homogeneous class and that any further classification amongst them would be violative of Article 14. On the other hand, the court clearly observed that it was not dealing with the problem of fund. The Railway Contributory Provident Fund is by definition of the fund besides the government obligation towards the employee under the CPF scheme to give the matching of the contribution begins as soon as his account is opened and ends with his retirement when his rights qua the government in respect of the provident fund was finally crystallized and thereafter no statutory obligation continues. Whether there still remain a moral obligation is a defined matter. On the other hand, under the pension scheme, the government's obligation does not begin until the employee retires, when only it begins and it continues till the death of the employee. Then, my lord, thus, on the retirement on an employee, government legal obligations under the provident fund account ends, while under the pension scheme, it's begins.
Where is the Krishna Kumar?
It is a reference. I did not bring it. Otherwise, the reference in this particular case.
But why not read the judgment instead of reading a reference?
Lordship, I have read it. Paragraph 32.
You have read it, but I have not read it.
That paragraph 32, Lordship. Paragraph 32.
But what is the point in reading a reference instead of the judgment? Might as well read the judgment.
Yes, because it's a latest judgment of 2022.
No, latest is okay, but you are referring to the explanation given in the earlier judgment. Which you have not placed.
1990, Lordship. 1990 judgment. It's a 1990, Lordship. 1990, then Nakara is 1983, Lordship. Then any other day I can place all the judgment, Lordship. When Lordship, paragraph 47 also, Lordship. It's a two defined group, not a homogeneous one.
My humble submission is that in the year 2013, the executive councils of the Dibrugarh University for the first time adopted the pensioner benefit to their employees who has satisfactorily performed their services. So therefore, this is a piece of beneficial legislation, my lord. And the pro rata pension, my lord, is awarded is nothing but it is an integral part of the superannuation. So if a person retired Yeah, or if a person completed 25 years service, then he is entitled for superannuation pension. Or if a person more than 10 years service.
Well, we don't need your views, although you are the counsel. You tell us from the basis of the judgments which are referred to. Have you read the judgments?
Yes, my lord, on the next day,
Then if it is on the next date, why are you arguing and wasting time?
no, I will submit.
If you have
judgment,
not read these judgments, you should come prepared and argue the matter.
My lord, with just
He is some difficulties, lossy. He is affected by heavy flood loss. In the yesterday
but
night, he
that-
is come loss. Yesterday night.
so, my lord, with all the
Even his house is still under lossy, water loss.
You did not make any prayer. We would have accommodated you.
Lossy.
oh,
Lossy.
You wanted to argue, we'll always hear you. But if you want to argue, be prepared and argue. On joint request, matters then referred to be listed again. Give us a date.
After 15 August lossy, may fix it then.
15 August.
After 15 August lossy, in the meantime lossy, he will be also lossy free.
You are affected in Gauhati or
No
in
lossy, no Sipsagar lossy.
Sipsagar?
Bedbari is still having Bedbari loss. Heavily affected. Still under water loss.
So what is the state doing?
Instead of doing with water loss, how can we remove it lossy water part? There was other things lossy, mud, everything was lossy by JCB and Poplar, other things we are using lossy. But Bedbari, the whole water is now in the Bedbari lossy. In other part, it is lossy already.
There is no outlet.
They are facing lossy. There is a lossy, the national highway is there. Even after 5 kilometers distance, railway board goes, then is there. That is the difficulties.
And the villages are on the side of the highway,
lossy.
below the highway level.
Below the level. That is the reason they are facing mass problems.
You are getting all the relief,
my
the
lord,
people around.
we have not received the government relief from the government, but we have received the NGOs peoples, they have supplied our.
Have you heard?
I have heard it. Otherwise, lossy, the government also providing whether they
Providing where
Yes.
if the concerned
Yes.
people are not receiving it, please take it up
lossy,
and ensure that the relief. What is the point in giving a relief
Then,
when the relief
then
is
lossy,
not
the
required?
Bedbari, Sontok and everywhere government relief is there. Why they are not getting it?
Now that is something you have to inquire and find out.
Absolutely.
Then Lordship, the Honorable Chief Minister also yesterday visited their place also. Bedbury and other.
No, at this hour, the least that can be done is to
Yes.
provide the immediate relief,
Loss.
which is possible.
Yes.
Rest of the things will come later. Then we'll fix it.
3rd week of August or last part
27th
of
August.
Loss.
27th August.
Yes.
Oblige.
Item 9 along with items 1 to 5.
In regard to item number 9, I'm appearing for respondent number 5. But today's occasion, I'm completely with respondent. Matter will be taken up another day. Readings are almost completed for item number 9. For others, I'm not appearing.
You are appearing on whose behalf?
Respondent number 5, Singhania University. Item 9.
Item 9, on the request made on behalf of respondent 5, Mr. T.R. Sen. Praise for accommodation as submitted. The matter will be, arguments will be led by a senior counsel. Submitted that the matters be taken up after 1 week.
Lordship, on 20 August.
20,
20 August.
all right, 20 August.
In item 1 to 5, Malad,
It is submitted at the bar by Mr. S. Das, Standing Counsel, Higher Education.
my lord,
That items number 1, 2, 3, 4, 5
my lord. Here only
are also similar matters, and all these matters be listed.
10 is also.
1, 2, 3, 4, 5 and 10 be listed together
Lordship,
along with item number 9.
in item number 1 to 5, in in that series, Your Lordship, item number 3 to 5, senior counsel as Borthakur is appearing. In these matters, Your Lordship, steps are complete, Your Lordship. Let this matter come up from in admission column along with that matter.
That is what we are saying.
Right.
This will come up along with 9.
In admission,
In admission
because
also.
otherwise these cases are fixed in order column. 1 to 6.
No, I
1 to
said
1 to 5.
it will come along with item number
Right.
9. That
Okay.
itself is
Lordship.
indicative that it will come
My lord.
after item number 9. in
Lordship.
admission. Yes.
And my lord, in item number 1 to 5, my lord, I have to file the affidavit also. So if
Parties may
possible,
exchange their pleadings in the meantime.
after 20, my lord, it will be better for me.
At least, my lord, like you have 4 weeks time, Lucy. In the meantime, we will file a affidavit. All the cases.
First week of September.
All right, 10th of September.
Lordship, oblige.
Pleadings may be exchanged in the meantime.
But last
one, appearing for number 12.
You give it to the court master or the council.
but only our prayer, but last chance may be given because last 2 years, but they are getting time. No, 2025 matter only.
It is made
24
clear that
matter
if
also.
the affidavit is not filed by the next returnable date, court will proceed to hear the matter on the basis of the pleadings available.
All the cases are 25 and 26 matter.
Yes.
I love the item number 10 was also filed. Activity.
Item
I
10,
have not received the affidavit in the no, I'm one.
we have permitted you to file, exchange your pleadings. Yes.
My lord, yeah, my lord, petitioner before your lordship, a science graduate teacher in his school. Yes, my lord, school toilet was broken on that time, on that day.
What
my
was
lord.
broken?
School toilet, my lord. It is a dilapidated condition, my lord. Therefore, my lord, his house is nearby, my lord. And he went to his house, my lord, for toilet purpose with written permission of the, my lord, head mistress of the school. In the meantime, my lord, local inspector came, my lord, and reported that, my lord, he is unauthorized absent, my lord. Therefore, he was suspended. And subsequently, my lord, one punishment is inflicted, my lord, without any legal procedure, and withholding, my lord, his increment with cumulative effect, my lord. And it is a settled principle of law, my lord. When any increment is withheld with cumulative effect, my lord, it is a major punishment, my lord. And this major punishment is inflicted, my lord, without following due process of law, my lord.
What is that due process?
Due process, my lord, proper, my lord, inquiry was not conducted, my lord. Inquiry report was also
Not submitted.
not submitted, my lord. And
Inquiry report not submitted.
therefore, my lord,
Please get the instructions whether inquiry was conducted.
Inquiry was done, my lord.
But was the report submitted to him?
As per the last order, madam, we are directed to submit the departmental record, madam, but I have not received, but I have received some instruction, madam, regarding this.
You tell
instruction,
us whether the inquiry report was submitted or not. Get an
madam,
instruction.
Already submitted. Already submitted.
No. Copy was served on him or not. He has to.
That instruction I have.
That instructions you take and tell us.
and then, my lord,
And if yes, then how it was served, by which communication?
and in the merit, my lord, he was very much present on that day, my lord. And I have, my lord,
You filed an appeal.
no.
He can't file an appeal unless you give him a copy.
And now, my lord, the attendance is, my lord, in a digital manner, page 39, my lord, I have taken abstract copy of the, from the computer, my lord, in the online. And it is very much clear, my lord, he was present in the school on that day. Page 39.
No, but if you are present, then you admit that you had gone out of the school.
No, my lord, I went, my lord, for half an hour. It is nearby his house.
Where have you stated that?
My lord,
Where have you stated?
under annexure 1, my lord.
No, where is the averment that you had gone for only half an hour?
Yes,
You had mentioned about the time you had come back. You went to school at 8:49.
yes, my lord.
Then 10:25, you had to leave for.
Paragraph 5, my lord,
And from 10:25,
Paragraph
you
5,
you
my lord.
came, you resumed your duties and left school at 3:26.
Yes, my lord.
Paragraph 5, my lord.
Yes.
The petitioner left the school at 10:30 a.m., my lord, for
Ah.
short leave for
No, no, no.
toilet.
What is that short period? Because as per the official timekeeping machine, your entry will be at 8:49
Yes,
a.m. Paragraph 4.
yes,
And for the day, you have left the school at 3:26.
yes, my lord. It is, my lord, the page, lordship kindly will page 39 in lecture 10, my lord, right hand side it is given, my lord.
39.
Page 39 in lecture 10, my lord.
Ah.
First, my lord, extreme right hand side, my lord, 849.49, my lord, and he left the school, my lord, 326.58, my lord.
Hmm.
In the meantime, my lord, he went, my lord.
That's right. So where is the record? For how long have you been absent? Is there any certificate by the headmistress or
Yes,
head
one
teacher?
application, my lord, I submitted. This is annexure 1, my lord.
But is there any endorsement?
Endorsed here, my lord.
Huh?
Page 19, my lord.
Page 19.
Page 19, my lord.
Yes.
No, already inquiry committee was done, and before inquiry, he has admitted, my lord, and as per
So you tell us whether the inquiry report was served on him.
kindly, madam, taken any other. After 2 days.
Mr.
Submit affidavit, detailed affidavit will be better.
Mr. A.M. Barbuya, learned counsel for the petitioner, MSA S. N. Fupan,
And
Standing Counsel, Elementary Education, is submitted that a new inquiry was conducted before imposition of punishment. However, state has not filed their affidavit. On instructions, these submissions are made by the Standing Counsel. Stop. However, she has no instructions as to whether a copy of the inquiry report was served on the writ petitioner after the conclusion of the inquiry and before imposition of punishment. So these instructions be placed into the court on the next day with due references from the relevant records. List on 19 August.
In the meantime, my lord, if they file, my lord, affidavit, it will be.
The respondents are also permitted to file their affidavits in the meantime.
Pertaining to last order, couple of days back, we have sent the letter to the petition to seek instruction, because by your phone we have not been able to. One more with the clerkship allows them to apprise the court.
It's already 2014 matter.
Yeah,
What is the
that
issue?
is-
What is the issue here? What is the issue?
We are challenging a speaking order also. Page 63. Private respondent was, service was provincial.
What is the writ petitioner doing now? Is he still in the school?
That is only the issue. Lordship, we have
Yes.
Lordship, in this matter, we have instruction that the respondent number 5, he had expired last year in the month of December. That is present scenario.
He had expired.
Yes, Lordship.
What is the status of the petitioner? Is he still there in the school?
Respondent 5 was working, but they had to take information regarding the petitioner, Lordship.
So there was one more with the
Heard
MZ Chaudhary.
counsel for the Mr. MZ
MZ Chaudhary.
Chaudhary.
Yes.
MZ Chaudhary for the petitioner, MS
You, Nanda.
Nanda, appearing for respondent number 5. The dispute between the petitioner and the respondent is regard to provincialization, regularization.
We have challenged the selection and appointment of respondent number 5.
Five.
Lordship.
Selection and appointment or
Selection and
regularization?
regularization.
Regularization of the private respondent. Number 5. As an assistant teacher Hindi in the so-and-so Muhammadiyah Senior Madrasa, the district of Golpara. So, submitted by the council to the petitioner that they are unable to establish any contact with the petitioner regarding as to whether the petitioner would be desirous of pursuing the matter any further. So, by the last order, dated 18/6/2026, the petitioners were granted time to obtain instructions. Whereas MSU Nanda, on the other end, was granted time to obtain instructions. Mr. Chaudhary today submits that they are still unable to establish contact. He submits that he be permitted 2 weeks further time or further time. Whereas MS Nanda Learned Counsel appearing for the respondent 5 submits on instructions that the respondent 5 is expired
In the month of December of 2025.
during the month of December 2025. Stop. By the earlier order dated 18/6/2026, it was made clear that the instructions as to whether instructions from the petitioner be obtained and no further time be granted as the writ petition is pending since 2015. So, considering the same, this court is of the view that since no instructions are forthcoming, the writ petitioner and obligor the petitioner is unable to establish contact, the writ petition can be closed at this stage. And also that the private taking into consideration that the private respondent has also expired. Writ petition dismissed for non-prosecution. Interim orders, if any, stand vacated. Pending IAs are also dismissed.
For starting the final hearing, in fact, my lord, I am appearing for respondent 10 and 11. My lord. We have filed an IA, my lord, for little clarification of the order.
For
little clarification of the interim order. My lord.
clarification of interim order.
Yes,
What
my lord,
matter is that
it will not affect that merit of the case. In fact, what happened, my lord, the petitioners in the batch of petition, they are non-sanctioned, they are working in under non-sanctioned post in different colleges of Assam, my lord.
Grade 4, grade 4.
And grade 4. They have challenged the decision of the higher education department, whereby it was sought for filling up of 114 posts by direct recruitment. Initially, there is an interim order. Your lordship will find the IA lordship taking up 2381 million in the item 13 million. The order dated 21/12/2018 million, page 22 number. Repetition number 8846, item 13.
Yes.
Lordship will see page 12, page 22. Sorry.
22.
Page 22. This is the initial interim order, madam. 22/12/2018, madam. So we find the last paragraph, madam. The respondent on the next fixed shall make their submission on the claim of the petitioner until such that the post concerned shall not be filled up. The entire 114 posts are statement. Subsequently, it was clarified that only those posts will be stayed in respect of which petitioners are seeking regularization. That order is also at page Lordship will find that page 31 is starts from page 31. Operative portion at page 39, last page. May I read? A perusal of the communication to the children do not reflect that there is any attempt to, on the part of the higher education department, to fill up those posts in respect of which petitioners claim to be accommodated. The said communication on the face of it shows that the said communication have been issued for the purpose of taking necessary steps for filling up of the vacant post in various provincial colleges of Assam. It also needs to be taken note of this court by the interim order directed not to fill up the post concerned in order to protect the right of the petitioner and applicants. Considering the above, the court therefore directs the respondents authorities may go ahead with the process of filling up of non-teaching staff. However, one grade 3 post in the respondent 10 college, this is the college in respect of my applicant method. 2 grade 3 posts in respect of respondent 4 college, such shall not be filled up. Well, what happened, my lord? There are 5 petitioners from Lanka Mahavidyalaya in the batch of rate petition, 2 in the first rate petition, 1 in the item 14 and 2 in the item 15. 4 of them they have withdrawn from the area of the petition by filing IAM. That your lordship will find at page 23 of IAM.
They have withdrawn.
They have withdrawn.
Only one remains.
One remains. He has resigned from the post in the year 2023. I have annexed a copy of his application and it was accepted by the governing body. Now, as on that, no petitioner from Lanka College is challenging the.
Is in this
Yes.
proceedings.
Yes, madam. Therefore, madam, my respectful submission that the interim order that may be clarified that the interim order shall not be operated against the Lanka Mahavidyalaya. And they are still as a area of
In the
respondent.
page number 39,
Yes, madam.
which is the Lanka Mahavidyalaya?
10. Respondent 10, madam.
Respondent 10.
10.
Respondent 10. Right. So how does it, you are filing this application on whose behalf?
On the from the college.
College behalf. Okay.
And that in spite of the fact that they have withdrawn from the area of petitioner, they are still there as a respondent in the the Lanka Mahavidyalaya and the governing body of the college.
No, in which writ petition this IA is filing?
IA is filed in the second petition, 8813, madam.
Huh?
8813.
No.
8846.
8846, madam, I have filed that IA number 2381. In 8813, I have filed 2379. And in 8817.
Please explain to us one thing.
Well,
These writ petitioners are seeking appointment in one college or appointment in all the colleges?
different colleges.
They're asking you, there are a bunch of writ petitioners.
Yes, Your Lordship.
So each writ petitioner is a claim towards one particular college.
No, madam.
No. May I just put it this way? In one of the cases, they're mixed, Your Lordship. Grade 3 and grade 4, Your Lordship, they are of different colleges. Like item number 13, there's the of Handic Girls College, then Madhya Kamrup College, then Banikanto Kakoti College, and Lanka Mahavidyalaya. The second writ petition also, there is a mixture of some college. And the third one also, there is some mixture of some college.
So far as this, what college is this?
Lanka Mahavidyalaya.
Lanka Mahavidyalaya. How many claims are there?
There are 5 claims.
5 claims in 3 writ petitions.
3 different writ petitions.
Yes, Your Lordship. And it's an admitted fact.
So you are saying that all these writ petitions have become infructuous?
No, not in practice. That claim from, there is no claim from in respect of Lanka Mahavidyalaya on that.
That is what we are asking you.
Yes.
Give us one writ petition, let us see.
Your Lordship will take the first writ petition, 8846.
8846.
Yes, sir.
8846 comprises of 6 petitioners.
My lord.
Yes, Your Lordship.
What is their claim?
They were seeking
Against whom? Here Lanka Mahavidyalaya is also one of the
Yes, madam.
persons,
9, 10 and 11.
10 and 11.
right?
Lanka Mahavidyalaya is added as respondent number 10 and 11.
Right.
And
Now-
your lordship will find page 5, initial petition, petition number 5 and 6, they were from Lanka Mahavidyalaya.
They were
Listener-
from Lanka.
Manish Bhattacharya and Pradeep Upadhyay.
That is what we are saying,
My lord.
that irrespective of the number of petitioners, the petitioners individually have a claim only in respect of one college. Yes or no?
Yes,
They are working as a.
yes, your lordship is right. Your lordship got it.
So out of these 5 and 6,
They are out. madam.
they're out. On
Well-
what basis?
They had a claim against the Lanka Mahavidyalaya
Yes.
because they are working in Lanka Mahavidyalaya.
No, so what is the, why have they abandoned their claim?
My lord, they have filed an interrogatory application, they are seeking withdrawal from the area of the petition.
5 and 6.
Yes, sir.
6, my lord.
6.
5 has resigned from the college.
5 has resigned.
My lord.
He is no longer claiming
Well-
anything.
6, your lordship will find the IA, my lord. I have annexed that withdrawal order, my lord, at page 23, my lord.
1 minute. How have you clubbed up all this in one writ petition?
Your lordship, they are
With different causes of action against different respondents.
right, your lordship. But the claim was with respect to regularization of their services because they have been working for the last 30 years. In a not
No,
admit-
claim is okay, but against different colleges,
Yes, your lordship.
in respect of different writ petitioners.
Yes, your lordship.
How are they clubbed together?
Because ultimately
One
the-
can understand respondent 5 and 6 filing a petition together because they have a claim against one college.
correct, your lordship.
But what about 1, 2, 3, 4 have claims against different
They are from
colleges?
different.
Right. Where is the IA?
IA, your lordship will find 2381.
2381.
Yes.
Page 23.
Page 23.
This is by petition number 6.
But why are we dealing with these IAs now? Let us hear the matter in the order. If we allow the petition,
Because they have withdrawn that there is no claim against the Lanka
we'll
Mahavidyalaya.
make it. We'll clarify it in the order.
Lordship.
We'll clarify it in the order. Yes, Mr. Sinha.
Yes, your lordship. Your lordship may, in that case, your lordship may take up on next Thursday for final disposal. Your lordship.
Therefore, the IA you are pressing.
No, I am not pressing your
I am
lordship.
pressing the IA.
He is pressing the I am not pressing the IA. I was just clarifying because my friends got mixed up with all those things.
He got mixed up because you jumbled up everything.
I'm sorry, your lordship.
It should be dismissed on the ground itself.
No, your lordship will not do that because rendering for the last 30 years.
What is your claim?
My claim is regularization, your lordship.
Regularization.
Because
You are
I-
still working.
Yes, your lordship. I'm still working, and few will be retired very soon.
How many years of service?
26, 27, 25, 28 years, 30 years.
95 and 99.
Sorry?
In one case, they were appointed 99 and
99, 98. We are working since last 25 to 30 years. your lordship.
As what? Ad hoc, contractual,
not contractual,
Temporary.
admitted because I'm for the college.
temporary.
Yes.
Temporary. In ad hoc, in aided state, they were appointed. Colleges were aided. Then in 2006, they were provincialized. I of them also, they have been working, they are continuing.
Now, in the provincialization, their names were not included.
Not in English. There is no post trade created. So college wrote for critical posts, but that was not allowed. Granted.
Is there any proposal sent by the government?
Proposals sent by the college from time to time.
And why is the higher education rejecting it?
They are not created posts, they are real.
Yes, Mr. Gogoi. In view of the recent
Yes.
Number of judgments.
Recent number of judgments of
I will
Supreme Court,
place more than
including
recent
our-
judgment.
including
Ah.
our own court judgment.
I will place the recent judgment of the Honorable Apex Court. Let petitioner finish his argument.
He
Then
is finished. He is asking for regularization.
He
He
is
is
not
working
entitled
for
for
20, 25 years.
He is not entitled for regulation only because the sanction push lawsuit, which was already there in the college, they have filled up in the regular modules. They are the additional, they have college internal engagement of the college. We have no relation with that particular push lawsuit. We are not engaged them at any point of time. We are not engaged them. Not a single penny was given from the government exchequer also to them. We are not engaged them. They are not the persons who is holding the push lawsuit. It is not fulfill the even the regulation principles laid down by the Honorable Supreme Court also.
They were working prior to the status of being provincialized.
Here, they may work closely prior to the state provincialized, but the college is a limited push lawsuit. There are 3 or 4 sanction push of the lawsuit get for employees. It was already filled up by the person's lawsuit. And that particular post is vacant, then go for direct recruitment. When the statute nowhere prescribed for regulation partners, there is no provisions for regulations. When deficit grants of H system college were taken under 2005 Act, the post which was lawsuit there, they are already regulations, provincialized laws, as per 2005 Act. Then 2010 rules come. Nowhere there is a provisions for regulation. The persons who is engaged by the college is additional post.
What is the say? 2000?
2005 Act and 2010 rules. 2010 rules is by way of the direct recruitment.
2010 rules.
10 rules.
What is the rule?
Assam college employees provincialization rules. Pilot may kindly come to page 496.
Assam?
Assam college employees provincialization rules 2010. Pilot may kindly come to page 496.
496.
496.
Yes.
So method of recruitment is Lordship Rule 5. Pilot may kindly come to Rule 5.2 Lordship. 2, 3, 4, 5 Lordship, all are there.
This is for principal.
Rule 5.1 for principal lordship. Rule 2 lordship. First 4 lines for the lordship lecturers and librarian. Then lordship in respect of in the middle of 4th line lordship. Grade 3 and grade 4 post. The list of candidates shall be collected from the local employment exchange / advertisement in newspaper lordship. And other part is lordship promotional part lordship. 3, 4, 5, 6. And all are the direct recruitment.
So this is after provincialization.
Lordship.
What about before provincialization?
Lordship.
When they were in the pre-provincialization stage, what?
Pre-provincialized state lordship in 1996 deficit grants in the H system of college lordship.
Where is that?
They have to lordship engage the persons who are sanctioned that, not beyond that lordship.
Where is that?
Deficit lordship just I find out. So Assam added plus employees rules 448. My lord may kindly come to 448 lordship.
Yes.
Method of recruitment is there, Lordship. Page 449, Lordship. Rule 5.
This is Assam Aided College Employees Rules.
There are grants in it college at the relevant point of time, Lordship.
This is only with regard to
In respect
lecturers
of
and
lecturers and professors, Lordship.
professors.
Rule 4 not in count.
Rule 4. Office assistant, they are not office assistants. They're temporary.
Basically, at that time, Lordship, it was the office assistant who said the relevant point of time. Now, Lordship, grade 3, grade 4, it was divided, Lordship. So when in grants in it college, Lordship, there is no divisions regarding grade 3 and grade 4.
Only temporary vacancies.
Yes. When
So-
temporary vacancy for 6-month period, Lordship.
Subject to necessary
Necessary approval from the directorate, Lordship. Director of Public Instruction, deed and Director of Public Instruction is at present, Lordship, Director of Higher Education.
And what is the provincialization? How many posts are there?
Provincialization, Lordship, grade A. Cert is now, I have not the cert, otherwise, Lordship, grade 3, grade 4, 3 post or 4 post, something is there, Lordship. And even department wise, there is a, Lordship, grade 3 post, Lordship, Science Department. Here are, Lordship, is there, Lordship.
It must be under the act, I think.
Lordship, it was not mentioned how many posts is there, Lordship.
No,
But-
this is the rule.
Rule, Lordship.
The-
Act is, Lordship, page 490, Lordship.
490.
And then, my lord, it will be very clear, Lordship. 491, my lord, may kindly pay us employee, Lordship. Then definition clause, it will be clear, Lordship. College. College means any non-government college in Assam in receipt of deficit in grant is system, Lordship. They are the deficit grant in system. Then employee, Lordship. Employee means an employee of a college. The persons who are, Lordship, come under the provincialization. That person come under the provincialization, Lordship. Both teaching and non-teaching appointed substantively against the sanction post. My lord, may kindly mark it. Then the existing employee, provincialization means, Lordship, taking the liabilities for payment of salaries, including DNS allowance, medical allowance, such other allowances admissible to the government employee of similar category in gratuity, pension, leave encashment, etc., as admissible under the existing rules to the employee of the state government, so and so, Lordship. So, Lordship, the employee was taken under 2005 Act, Lordship. 5 Act of both teaching and non-teaching staff, Lordship, were engaged in the sanction process. They are taken by the, Lordship, 2005 Act under the provincialization, Lordship. Otherwise, they are the deficit grants in the system of college before 2005, Lordship. So they are not within the, Lordship, definition clause also, employee, they are not within that particular purview also, Lordship. To be also, Lordship.
What is the sanction post?
Lordship,
What is the sanction post?
sanction post, the post which was created by the government at the relevant point of time,
No,
Lordship.
no, no. This is Provincialization, Police Provincialization Act.
Lordship.
So
In deficit grants in a system, college also, Lordship, there is a sanction post, Lordship. There was a sanction post, Lordship. Sanction post in against the lecturers and Lordship against the Lordship non-teaching staff also, Lordship. And those persons who are engaged in that particular post, Lordship, they are treated as an employee, Lordship.
where is the provision to show that in deficit grant system,
Lordship.
also the posts are to be sanctioned by the higher education or
It
some?
is there,
authority?
Lordship. It is there. It is Lordship page 4.
Page 491.
491.
Page 491 and employees provision. Big provision. Subject to the provisions of Article 30 and into the 9th of the Constitution, all employees. Doesn't say sex on them.
All employees, we have to go by the definition of the employee, Lordship. We have to go by the definition of the employee. We cannot mislead the court, Lordship. By Lordship, picking one section, Lordship. Section, then what? Who is employee? Employee have to determine, Lordship. Employee have to define in the Lordship section 2B, Lordship. 2B says that employee means an employee of a college, both teaching and non-teaching post, appointed substantially against the sanction post, Lordship. We have to read it along with lots of definition clause, Lordship. Then, Lordship, section 3 will come, employee to be provincialized. Who are the employee? Employee are the
So what
persons.
is the difference between employee and existing employee?
Existing employee is the person's, Lordship, employee both teaching and non-teaching appointed substantially against the sanction post. Same thing, Lordship. Who or has been in service prior to, Lordship, 1/1/2005. 1/1/2005, the Provincialization Act is come,
What
Lordship.
is the meaning of a sanction post?
Sanction post, the post which was, Lordship, sanctioned by the government, Lordship, and under which post, Lordship, government has given the fund, Lordship.
Under what provisions? Under what provisions are the posts to be sanctioned? Under what rules or act? Yes, Mr. Sinha.
Your Lordship, irrespective of all these provisions, the law laid down by the Honorable Apex Court is very clear. If I may, if the Lordship kindly allows me to place this will clarify the entire thing. Forget about what is there, whether the posts are sanctioned or not. I'm not denying or disputing on that issues. But what has, I'm sure the Lordship has gone through this, even then I'm placing it. I'll place 3 judgment, Vinod Kumar, Jaggo and Sukendra Bhattacharya.
Those are with regard to a person rendering service in a government or a government department, right? Here is the case where when you were started rendering service, it was not under the government.
It's still government, Your Lordship, as of now.
It was not under the government.
But it was
You had
government
rendered,
aided. It
you
was
had
government-
rendered services under a private college, aided college.
Yes, Your Lordship. So in
Now,
that,
in that aided college, how did you come to be appointed against what post? Is there a set of rules which govern them?
no, Your Lordship, we were appointed in a non-sanction, admittedly. What was the precedence that was being followed? If I may honestly admit that. The peoples were appointed by the resolution of the governing body. Before us also people were appointed. I'm sure my respected senior will place those records if required. And as and when the post fell vacant, those people were regularized. It was only when we were supposed to be regularized, there was an order not to regularize any further. Then we came up before
You
this court
regularized by whom?
by the Director of Higher Education.
Where is that?
Our proposals
Order.
were sent. If I may draw your Lordship's kind attention to page 58.
58.
Yes. The Lordship is taking up the first petition, 8846.
it has come to the note that some provincialized colleges of Assam has submitted a proposal to the Directorate for regularization of services of non-teaching staff against the valid sanction post. Government of Assam by memorandum such and such has banned the appointments of teaching and non-teaching staff against the non-existing post of the deficient 20 NEET college. Therefore, all principals of provincialized colleges are directed not to submit any proposal to this directorate in this regard. However, government such and such has approved for filling up of 114 numbers of vacant posts of grade 3 of the various provincialized colleges of Assam. So this is
So
the
it talks about vacant sanction post.
yes, Your Lordship.
So sanctioned by whom?
Sanctioned by the government, Your Lordship.
But you were only aided. You were not provincialized that time.
Your Lordship, we have been working. Your Lordship will kindly appreciate the fact that we have been working for the last 25 to 30 years. And that is how the Vinod
We are
Kumar
not
judge-
questioning your length of service. We are asking you, this term vacant sanction post
Yes.
is defined under which rule or act? That for your appointment, there has to be a vacant sanction post.
Yes, Your Lordship.
Number one, who sanctions this post? In your case, you were appointed by the college authorities, governing body.
Yes, Your
Is
Lordship.
it sufficient to say that it is a vacant sanction post?
No,
Then-
we were working in a non-sanctioned post.
Non-sanctioned. So who will have to sanction it?
Your Lordship, the government has
The
sanctioned it.
government. So there has to be a set of rules. Let us look into the rules.
Yes, Your Lordship, we go to the rules, Your Lordship. But if Your Lordships kindly permit me to place one paragraph from Vinod Kumar. The judgment is very specific and it covers my case, Your Lordship. 2024 9 SCC 327.
Yes.
Para 5. I'll come to para 5 straight.
Para 5.
Page 329. Having heard the arguments of both the sides, the court believes that the essence of employments and the rights therefore cannot be merely determined by initial terms of employment. When the actual course of employment has evolved significantly over time, the continuous service of the appellants in the capacities of regular employees performing duties indistinguishable from those in permanent post and their selection through a process that mirrors that of a regular recruitment constitute a substantive departure from the temporary and scheme-specific nature of their initial engagement. Your Lordship, we are
Now you come to para 2 of the said judgment.
pursuant to the
Read para 2. Yes.
Pursuant to the notification dated 21/2/1991, the appellants were initially appointed to ex-cadre post of accounts clerk after the selection process involving written test and viva voice interviews. After the rejection of the representation for regularization to the divisional railway manager in 1999, the appellants approached the Central Administrative Tribunal by way of original application. The tribunal by order dated such and such dismissed the application of the appellants, concluding that their appointments were temporary and for a specific scheme, thus not entitling them to regularization or absorption into permanent post.
So they were working under the government.
Yes, Your Lordship.
Now, as far as you are concerned, your initial employment was not under the government. It was on a private college. You are saying that the government is saying that had your appointment been against a sanctioned post, then you would have been on a different footing. Now the question is, under what rules does it say that for a private college to appoint, there has to be a process by which certain posts are sanctioned by the government? One. Number two, you having worked there after the college got provincialized, is it a case that the entire college with all the staff, lock, stock and barrel gets provincialized, or it is only those selected, identified posts which are provincialized? Meaning thereby that in a college which is provincialized, not all the posts may be provincialized. Whether your post was under that consideration for being provincialized or not, or it is in excess of the number of posts quantified or notified to be provincialized. So your initial entry as this reference that you are making in Vinod Kumar is with the nature of your employment, quite right. But you will have to first show that the government is under liability to regularize you. If you are not working under the government, even indirectly, how do you claim a liability of the government to regularize you from such and such date? If you are unable to point out that the post in which you are still working was also a post required to be included in the provincialization, but was not included because of some lacuna on the part of the government. How do you identify? Meaning, thereby, if there are 5 posts to be included in provincialization, you are in number 6 or 7. Whether you can raise a claim that notwithstanding these 5 posts, since you are working, 6 and 7 posts are also to be provincialized or regularized.
What fell from your lordship, I could get it.
The judgment you are relying on would be in the context of a matter where you are appointed in a proper post, but on temporary basis. Or like you, there are similar persons who are appointed on temporary basis. Part of them have been regularized, provincialized. You have been left out. Certainly, the judgment would be applicable.
In fact, your lordship, I have also stated in my petition categorically, if I got your lordship correctly, that this was the process in which the peoples were appointed and regularized. It was the last batch.
Therefore, we are asking you repeatedly what is the meaning of the term sanction vacant post? Who sanctions this post? Is it by the governing body? Is
No.
it by the government?
It is by the government.
So, if for the government there has to be a proposal by the college, for which it must be guided by a set of rules or a notification that how many posts are to be sanctioned.
But your lordship has a one-time measures, what I could gather from reading.
No, that one-time measure would not be restricted only to your college.
No, this what I could gather. Your lordship is right. Perhaps I could not place it in a proper manner. The reading of this judgment makes it very clear. If the persons are working, be it in temporary, be it in non-sanction, be it casual, whatever incapacity may be, if they're working for a long time and they are discharging the duties and responsibilities as that of the regular employees, then these people has to be regularized.
Subject to their not being covered or excluded by a set of rules. There is a set of rules here, provincialization. It defines the number of posts which will be provincialized.
Your lordship, in that case, your lordship.
Therefore, the persons who are provincialized in terms of this particular act or rule, and the persons who are outside the purview of these posts will not be on the same footing.
Your lordship, I may place Sukhendu Bhattacharya for a moment. I'm sure your lordship has gone through it. Para 64. The present appeals could have been allowed on the basis of discussions and herein above, as the unequal and arbitrary treatment meted out to the appellants is apparent on the face of the record. However, the facts and the circumstances of the present case necessitate certain observation regarding the manner in which state has handled the issue of regularization, the way in which assurances were extended, policies were formulated and partially implemented, and thereafter altered warrants closer scrutiny as to the ensure adherence to the standards of fairness and accountability expected of the state and its instrumentalities. So whatever the policies are there or it may not be there, once you have extracted their services, there is an implied.
No, I don't think that is the import of the judgments.
Further, it says, your lordship.
If that be so, it will displace the entire.
Your lordship,
create problems for the entire service industry in the state.
That has done, in fact, your lordship.
So that is a matter where the master roll workers.
Right, your lordship.
Regularization was in question. Master rolls being appointed by the state. There is no rules governing master roll workers. There is no act governing master roll workers. In the context of your case, you are seeking provincialization under an act.
Yes, your lordship.
So you have to satisfy the court as to how you come within the purview of this act. Factually. And then we come to the judgments.
Unsatisfied.
The vacant sanction post is not defined here. Who sanctions it?
It's the government.
What is the process? If the college is required to send the proposals to the government for getting a sanction, whether it was done in your case, whether without waiting for the sanction, whether your appointment was done. These are all factual issues.
Your lordship, as regards the second query which fell from your lordship, admittedly, we have been appointed on some assurances that will be regularized. But I'm sure my
So
respected
those
senior,
assurances were given by the college authority.
yes, your lordship. Now my respected senior on the other side will be able to produce the records because they have not filed the affidavit. So it's in the hearing stage. So my respected senior may produce to that extent that whether our names were sent or not. What I could gather from the records is that there was the moment we are supposed to be regularized, that notification came. And thereafter it stopped the entire process, your lordship.
That notification again refers to vacant sanction posts. Notification says the government has approved 114 posts of vacant sanction posts.
Vacant sanction.
So what is this vacant sanction post?
Your lordship, sanction post means the post which has been created and wherein there is an SIU approval for appointment.
Under what provision? Under what modality is set?
No, that is not exactly. That is not there.
That is what we have to understand as
Yes,
to
your
how these
lordship.
posts were created.
Right, your lordship. And in fact, my respected senior has to also produce the record to that extent that how these things was executed and done. In our case, at least, your lordship.
Any affidavit filed, Mr. Chalia? No. You are appearing for Handic.
Handic. What English copy?
Sorry, look.
Corporate fine, yes.
আপনার লাগিব স্যার
Here we have stated that at paragraph 6, that legal statements made in paragraph 10, 11, and 12 of the deponent states that as requested by the state government in the higher education department, the college authorities had forwarded a list of employees of grade 3 and grade 4 as per seniority or further requested to sanction more posts in grade 4, mainly to cope with the Department of Science and Arts. Here we have given a list of employees also. List is there annexed.
The names of the petitioners are there.
Yes.
Is included.
Included.
Then what happens after that?
In the meantime, this notification came. That was stopped.
Now, so essentially what you are saying is that these persons whose names are there at page 68
Yes.
were all appointed without the post being sanctioned.
No,
Or prior to the post being sanctioned.
Prior to the post being sanctioned, yes. Because after appointment, it is forwarded to the state government or sanctioning of the post.
Under what provisions are you following this procedure?
That's being followed by the college, no? Whenever a requirement is here. As in the case of lecturers also. Because there are science laboratories and other things, so more grade 3 employees are required, grade 4 employees are required.
So where is that chart? How many posts? Grade 3, grade 4?
That page 7 in the ADA, I've given a list.
No, that is for your college. I mean,
Yes.
for provincialization, like schools, there must be a chart, isn't it?
I think that comes out.
Mr. Gogoi?
is there in 2011 Act. Basically, that was followed by the earlier Act. 2011 Act, which are stuck down just just for lawsuit perusal, the procedure, employment parties there. And
2011 Act. 11 Act.
647, just 647 lawsuit.
647.
The post lawsuit has 647. Yes.
Six 47.
This is the SART lawsuit. They basically follow the earlier
This
That's a-
covers the colleges also.
colleges, college, degree college lawsuit. And my lord may kindly pay the SART. Senior assistant, junior assistant, library assistant 5 lawsuit, library assistant 1, get for 6 lawsuit. And the additional stream lawsuit, if the additional stream is there, then it's depend upon the lawsuit students.
This is not in force now.
No, that is not that was struck down. Basically, that particular SART was derived from the
In place of this act, is there any new act which has come?
2017 Act. But that particular SART is lawsuit by following the earlier.
No, that is what I'm asking you. This 2011 Act is essentially for schools,
It is for college, school,
everything.
everything. College, degree colleges, school.
That was
Degree-
amended in 2012, your lordship, and in
Just I
2013.
give for a sample lawsuit, we have just shown it to lawsuit.
So there is no separate schedule like this in the college.
In the degree colleges, lawsuit may page 663 lawsuit. That part lawsuit.
663, yes, degree college.
It is the lawsuit basic push the there lawsuit. If lawsuit the lecturers in per department, 3 lecturers is there lawsuit. If the major course is there, then lawsuit another one is added lawsuit. Then
This
four.
this is replaced by which act? 17.
17 Act.
17 Act.
Basically, that schedule was followed lawsuit on the earlier convention. That schedule was prepared lawsuit.
Seventeen Act has no schedule.
No schedule. Given lawsuit that on the basis of that, the push to a given lawsuit and all the existing push is there in the particular colleges lawsuit. And even lawsuit after coming into force of 2005 Act lawsuit, not a single person was regularized lawsuit under the 2005. There is no provision of regularization lawsuit. We have to go by the direct recruitment. If vacancies arises against the sanction post lawsuit, we have to go by the direct recruitment lawsuit. And those persons who are come under the category of employee lawsuit, they are already provincialized lawsuit. Those who are in the aided colleges lawsuit. And that particular persons, when they go on superannuation, then it will come for direct recruitment lawsuit. There is no process for adjustment and regularization lawsuit.
So as on date, there is nothing.
Nothing. If lawsuit any post vacancy arises lawsuit, then it will go by the direct recruitment. If additional post is required, it depends upon the additional stream lawsuit. Then also lawsuit, the post will be created by the government, then it will be filled up by the direct recruitment.
What
If
will happen to these people?
lawsuit, they have to participate in lawsuit.
They'll be overage.
They can apply for age condonation also.
Will retire, your lordship, in the next 3 years.
Otherwise, if the rule is not permitted, there is no statutory prescription lawsuit. We go beyond that lawsuit.
But you don't have a rule.
Lawsuit. We have the rule lawsuit, 2005 rule lawsuit, 2005 Act, 2010 rules lawsuit.
There it does not define what is a sanction post.
Sanction post lawsuit,
Sanctioned by whom?
sanctioned by the government lawsuit,
I know, but what is the manner?
manner lawsuit,
Do you have to sanction
as per
post?
the requirement lawsuit, every department has a 3 post lawsuit.
As that all these particulars are available where? You said 3 posts.
Lawsuit.
Where is it defined?
I can place it lawsuit. If the SART, I can place it lawsuit.
Place it.
I can place it. The SART lawsuit, the exact requirement, exact vacancy. I can
That you
place it.
place it.
I
It's
can
not
place
part of the affidavit.
Yes.
It is not part of the affidavit.
That is not the, not the issue. It's not the, otherwise, losses, it is admitted fact that they are against the non-sanction. There is no dispute.
So that is what we want to
Not-
understand,
loss.
that who.
How many
Is
posts are?
there a sanction required earlier,
Lordship,
or is the person to be appointed and then the names are forwarded by the college as they are doing it now?
this is not the procedure.
Then
The procedure, the procedure is that, as per aided college
the
rule,
procedure will have to be laid down.
procedure in the aided college rules is the procedure is there, it is the under the, they have appointed, it must be approval from the director of the higher education department, and then lordship,
All these things are not
Yeah.
here in the aided college rules. It's not there, it only says sanction post.
college cannot appoint lordship beyond
Aided
the
college
sanction.
in fact has no reference to grade 3 and grade 4.
That is the grade 3, grade 4 concept not there in the 1960 laws. It is the office assistant concept is there. Okay, at the relevant point of time, the concept of grade 3 and grade 4 is not there. The office assistants covered everything.
But then the office assistants are to be appointed after due advertisement.
Lord, that is the procedure.
No, no, you say that these claims of the petitioners are not acceptable because they are appointed in non-sanctioned posts. Now, firstly, to whether these posts are will have to be sanctioned by the department.
It will be sanctioned by the government. Every aided college, lordship,
Uh,
every aided college, as per the requirement, as per the every department, there is a sanction strength is there. Say example, lordship, in case of economics department, there is a in general courses
but
is.
these are all mentioned. These are supposed to be a part of the rules, service rules.
Lordship, this is a circular is there, government. I can press that at the relevant point of time. How many posts is there in a particular college?
Place it.
Lordship.
Let us understand.
Lordship. Otherwise, there is no dispute, not a single disputed fact is there, lordship. They are serving as a non-sanctioned post. They are engaged by the college, lordship, and they are at the relevant point of time when a provincialization took place from the deficit grants in system to lordship provincialization, they are not within the considered zone, lordship.
But the higher authority also, how can we not have a report of excess persons being appointed, assuming there is a sanctioned post? You say that these people are appointed non-sanctioned posts. Why was it permitted by the higher education department?
Even
Why no
2000
steps were taken by the
steps
department?
were taken again and again in 1990 also, 2004 also, 2010 also, even also 2021 also. We have given a notification to the concerned colleges. It will be borne by the college, not a responsibility of the government laws. They cannot appoint. Even also the bar which was made by the government, it was upheld by the Honorable our High Court 3 judges bench laws. Non-sanctioned post we cannot lawfully appoint. That was also lost.
Place all this
Lost L
before
place.
the court.
Lost L place.
When
I am ready any day lost.
during the course of the hearing, the questions for the relevant rules or the procedure prescribed for sanction within quote sanction vacant posts required to be available before for an aided college for appointment in respect of grade 3, grade 4 employees came up before the court. The Standing Council Higher Education submits that there are circulars and poems available, which he claims he would like to produce before the court, along with relevant judgments. Matters therefore stand deferred to be listed on after 1 week.
After
What about this IA? We can pass orders on that day?
I lost the college are affected loss. Yes, because I lost it.
IA don't know. IA number 2381. Mr. P. Hazarika.
After 15 August.
Yes, we fix it. Mr. P. Hazarika, Learned Counsel, appears for the applicant. He submits that by the order, initial order dated
22/11,
21,
21/12,
2018, passed in WPC 8846/2018. The respondents were directed not to fill up the posts claimed by the petitioners. Stop. The petitioners are claiming regularization
regularized.
in the cadre of grade 3 and grade 4 in the Lanka Mahavidyalaya, insofar as the present IA is concerned. So, this interim order was further clarified by order dated 13/5/2022, whereby the following whereby the order was clarified as under page number 39, tick mark to tick mark of the IA. So, the learned counsel for the applicant submits that the applicant college is arrayed as party respondent number 10.
10 and 11.
10 and 11. Only 10 so far as the order is concerned.
My lord, the governing body of the college also.
You are asking modification of this order. The
Yes.
order, there is no reference of 11.
My lord.
Why are you getting and bringing another the respondent number 10, WPC number so and so? Stop. It is submitted that the writ petitioners there were 5 writ petitioners in WPC number so and so.
Six.
Huh?
6.
6.
6.
There are only 5 here.
Lordship may have that amended cost title. Initially, there are 6 million. Petition number 5 and 6 are from Lanka. Lordship will see that.
In your IA, you see?
Yes, my lord.
In your IA, page number 6.
No, I have written that amended cost title.
So we go by that only.
Lordship will see the page 19 million.
19.
Page 19.
5 and 6.
Yes, ma'am.
The writ petition was filed by 6 writ petitioners, wherein petitioner number 5, Sri Manos Bhattacharjee, and petitioner number 6, Sri Pradeep Upadhyay, had claims in respect of regularization of their posts, grade 4, grade 3 posts in the Lanka Mahavidyalaya, in the district of Ojai, Nagaon.
Yes.
Ojai. Stop. The learned counsel for the applicant submits that the petitioner number 5, Sri Manish Bhattacharjee,
He
resigned from the services on
2/5/2023.
5/2023. And the petitioner number 6,
My lord.
Sri
Yes, withdrawn.
Pradeep Upadhyay, is
Yes, withdrawn, my lord, by order dated 22/9/2025 in IA number, my lord, 3118 of 2025.
he
Yes.
has withdrawn
Yes,
from
yes,
the
yes.
writ proceedings by the order dated
22/9/2025, passed in IA number 3118 of 2020, page 23.
his name was struck off from the area of the writ petitioners, and his application filed by the said writ petitioner as an applicant, being IA number 3118 of 2025, wherein by order dated 22/9/2025, the IA was allowed, and the name of the writ petitioner number 6, so and so, was struck off from the array of the petitioners in WPC 8846 of 2018. Stop. Where it is submitted that view of the matter, as on date, insofar as WPC 8846 is concerned, 2018 is concerned, there are 4 petitioners, and none of these 4 petitioners have laid any claim in respect of Lanka Mahavidyalaya. Therefore, the interim order dated 13/5/2022 is sought to be further modified.
No, interim order at 21/12/2018, sorry.
21/12/2018, which was clarified by order dated 13/5/2022,
That's
is sought to be further modified in respect of respondent number 10, namely the so-and-so college herein, to the effect that in view of the writ petitioners 5 and 6 not having any claims in respect of the Lanka Mahavidyalaya College, the college authorities be permitted to proceed for recruitment by said posts. Stop. Para. Mr. R. Sinha, counsel for the petitioner, does not object submissions made by the counsel for the applicant or disputes the position on facts. Objections are also raised by Mr. K. Gogoi, learned counsel representing the Higher Education Department, and the counsel representing the other parties, the group of writ petitions. So, that view of the matter, considering the submissions made, the IA stands allowed. The interim order dated 2000. Order dated what was
well,
the
yes.
Huh?
21/12/2018,
which was modified by the order dated 13/5/2022, is further modified to the extent that the interim order will not operate against the respondent number 10 college, namely Lanka Mahavidyalaya. Stop. The interim order stated 21/12/2018 and 13/5/2022 shall be read together with the order passed today in the IA. That's so. The operation of the interim order, save and accept, clarified by the order today, will continue to be in operation.
Look,
IA accordingly stands allowed disposal of.
only prayer millet that Lanka Mahavidyalaya, they may be strike off from the area of respondent 10 and 11.
Is that a prayer also?
Yes, ma'am.
The IA stands allowed, therefore, Lanka Mahavidyalaya
And the governing
body, respondent number 10 and 11 are struck off from the array of party of respondents.
Okay.
The writ petitioner will file amended post title before the registry within 1 week. There are some I's in the other
The
matters.
same order in respect to Lanka Mahavidyalaya in the WPC 8813 matter, one petitioner from Lanka Mahavidyalaya, this is number 5 matter.
IA number 2379 filed in WPC 8813. Here, one petitioner.
One petitioner. Pradeep Saikia, this is number 5. Yes.
Pradeep Saikia.
His respective withdrawal order, same date, my lord. IA number 3119.
1 minute. Sorry. This is petitioner number 10. Petitioner 10 in WPC 8813.
He was petition number 10. 10.
So what is wrong with him?
Well, he has also withdrawn.
He has also withdrawn.
Well,
He has withdrawn by which order?
Lordship or page 22, annexure B. IA is 3119. Same date, my lord.
Okay, so
29.
in this IA, right? It's an IA filed by Longa Mahavidyalaya, seeking bring on record, in fact, that petitioner number 10, Sri Pradip Hoikia, WPC 8813 of 2018, had filed IA number 3119 of 2025, seeking deletion of his name from the array of writ petitioners, and which was allowed by order dated 22/9/2025. So the other writ petitioners do not have any claim in respect of Longa Mahavidyalaya. Therefore, the interim order passed on same date,
Same date.
21/12/2018, subsequently modified by 13/5/2022. The modified in respect of respondent number 10,
Well,
which is Lonka Mahavidyalaya, and the name of the respondent 10 and 11 is struck off from the array of respondents in WPC 8813 of 2018. Heard so and so, considering the submission. The earlier interim order dated so and so, clarified by so and so, is hereby modified to the extent that the interim order will not operate against respondent number 10, in view of the fact that none of the writ petitioners barring respondent petitioner number 10 has any claims against so and so college, and the claim of the writ petitioner also is not does not exist today in view of the order dated 22/9/25 passed in IA number so and so, whereby the name of the writ petitioner was struck off. IA so and so allow, name of the respondent 10 and 11 struck off, petitioner to file amended course title.
third, my lord, in WPC 8817, my lord.
Third IA is 2380, WPC 8810.
Well, one
Here is the petitioner.
here, my lord, petition number 2 and 3, Kaushik Ranjan Dev and Vinita Pal, they were from Lanka. They have withdrawn.
There we go.
Yes, ma'am.
Kushal Kolita.
No, my lord. Yes, my lord. First petition,
No, number 2 and 3.
2 and 3.
Okay, yeah, number 2 and 3 was Kaushik Ranjan Dev and number
Vinita
3 Vinita Paul.
Well,
They have filed an IA
yes, my lord.
3120 25 in WPC 8817, whereby order dated 22/9/25, their names were struck off from the area of the writ petitioner. Therefore, and a consequent thereto, none of the other writ petitioners have any claim in respect of respondent 10 and 11,
No,
which is
here, my lord, 4 and 4, my lord.
respondent
4.
4,
Lanka, my lord, 4.
only 4.
Only 4.
No, 4 and 5.
4 and 5.
4 and 5, namely Lonka Mahavidyalaya. Stop. Therefore, further prayer. Therefore, the pray that the name respondents 4 and 5 is struck off from the array of parties. With a stop. Further prayer is made that the interim order dated 21/12/2018 is to modified by the earlier order, modified by order dated 13/5/2022, be also clarified or modified. Here it is respondent 10, it's the same thing. Same order is there.
My lord.
But there also your respondent 10.
No, my lord, here, respondent 4 and 5.
4 and 5.
Always array date is 4 and 5. In the other case, where the order was passed, the respondent 10. Always is same.
So the interim order is directed not to be operative against the Lonka Mahavidyalaya, respondent number 4 and 5, in view of their names being struck off from the array of the respondents.
Fine.
I stands allowed. Suppose
Oblige.
Mr. D.P. Cholia, Senior Counsel, ested by so and so, appears for the
4 and 5.
4 and 5 in WPC 8846 8813. Yes.
Public. Item 16.
This would have been issued, but I had gone through the brief. It's an affidavit has been filed, para 7. My contention is that I am working as a school mother from 1999 in Sisumara MP school in a sanctioned post because I am getting a definite pay of 1050 as per the rules. It's a fixed pay. Now I contend that it is a sanctioned post because it is created by an authority. It carries definite duties and it has a pay attached to it as part of fundamental rules. Now they say that I was appointed in the post of my mother-in-law. They say that those posts have been abolished. They don't directly say in the affidavit that I have not been appointed in a sanctioned post. Therefore, on that context, for para 7 only, I need to find a short reply.
Counsel for the petitioner prays for 2 weeks' time to file rejoinder affidavit to the affidavit filed by the Elementary Education Department. Prayer made is not objected to by the Standing Council Education, Elementary Education. Matter stands deferred to be listed after 2 weeks.
Lordship, matter related to compassionate appointment law. Lordship, the petitioner's mother was died on 22/7/2010. Lordship. Thereafter, on 30/3/2011, he applied for compassionate appointment. Lordship, and according to the DLC, page 18, Lordship, initially on 28/5/2013, Lordship, the DLC recommended the name of the petitioner for appointment to the post of assistant teacher. Lordship, with a remarks column that since the case is prior to August 2010, percentage criteria not. So that was recommended to the SLC, Lordship. Then SLC rejected my case, Lordship, on the ground of lack of vacancy. Thereafter, Lordship, I preferred a writ petition and before dishonorable court. Dishonorable court directed to reconsider my matter, Lordship. And then, Lordship, the DLC again rejected my case on the ground that, Lordship, the percentage criteria was not met. In case of the petitioner, Lordship. Then I preferred another writ petition, Lordship, which was disposed of by the order dated 27/4/2018, Lordship, page 27, Lordship. Wherein dishonorable court clearly directed that, Lordship, since the case application of the petitioner is prior to August 2010, Lordship, then percentage criteria is not required. So accordingly directed the SLC, Lordship, to reconsider my case afresh, Lordship. Your Lordship may kindly peruse the order 26, page 26, Lordship, page 20, page 27 onwards, Lordship, the order, Lordship.
Yes.
So thereafter, Lordship, the SLC, page 29 is the SLC minus, Lordship. On 28 December 2020, Lordship, page 30 is my name, Lordship. They have rejected my case, rejected due to non-availability of NCT norms and also do not come under the purview of OM dated 2/6/2000.
So my case again rejected due to non-availability. This way or that way, Lordship, they have rejected my case on percentage criteria.
What is the NCT norms?
NCT norms that 50% is required, Lordship.
Where is that?
In higher secondary Lordship. That is not here, Lord, annexed with the writ petition, but
Where is the DLC minutes?
yes, Lordship. Initial DLC minus, Lordship, page 18, Lordship.
18.
Page 18 is the translated copy, type copy, Lordship. And the
When did your mother expire?
on 22/7/2010, and I submitted my application on 33/2011, Lordship. Your Lordship may kindly see page 22, Lordship, the original minus, Lordship. Page 22, serial number 14, Lordship.
14? 40?
No, 14,
14.
Lordship. 14. Y. Komaljit Singh, so and so. Date of application here 33/2011.
What is PC criteria?
This is percentage criteria.
How can PC criteria be percentage? What is PC criteria?
Because there's a notification of the NCT.
Where is the NCT notification?
That notification also not available, Lordship. But as per that notification, for teacher, appointment of teacher in LP schools, Lordship, the 50% marks is required in HSLs, higher secondary.
So where is the recommendation of the DLC?
This is the recommendation.
Recommendation for what post?
For assistant teacher, LP school.
Assistant teacher. Okay.
Then, Lordship, my case was rejected by the SLC, Lordship, due to lack of vacancy, and I approached dishonorable court. Dishonorable court remanded back to the SLC for a fresh consideration. But now also, Lordship, again the SLC rejected my case on the percentage criteria. Then I approached dishonorable court. Now, Lordship, this is the fourth writ petition, Lordship, for dishonorable. So all the times, Lordship, dishonorable court directed the SLC to reconsider my case, Lordship. Ultimately, Lordship, what happened, Lordship? Now the authorities, Lordship, rejected my case on the ground that the candidate applied after 1 year from the date of death of the deceased. Now a new ground, Lordship. That was annexed with the affidavit in opposition filed by the respondent, Lordship. Page 65 of the affidavit in opposition, Lordship. That is on 22nd January 2022, Lordship. The SLC page 65 of the affidavit in opposition filed by the respondent.
When did your mother expire, you said?
My mother was expired on 22/7/2010.
22/7/2010. When did you apply?
On 33/2011, Lordship. Within 1 year, Lordship. This is itself, Lordship, mentioned in the first DLC minus, Lordship. Page 18 of my writ petition, Lordship. Date of application mentioned as 33/2011.
Where is it in the DLC? Is it mentioned in the DLC?
Yes, Lordship, it is mentioned in the DLC, Lordship. That page 22 of my writ petition, Lordship. Serial number
33.
14.
Applied.
Second column, third column, Lordship. 33/2011 for 80 LPS.
And what is the final rejection of the SLC?
Final rejection is, Lordship.
Non-availability of the NCT norms. This
No,
is
Lordship.
No.
That is earlier, Lordship.
Earlier. Now,
Yes, Lordship. Now, the impugned minus, Lordship, page 65 of the affidavit in opposition.
65.
Of the affidavit in opposition filed by the respondent lordship. 22nd January 2022.
Yes, your name is?
My name, serial number 9, top lordship, Y. Komaljit Singha. Rejected on the ground that the candidate applied after 1 year from the date of death of the deceased.
Yes, respondent. On the facts urged, it appears to be an incorrect statement.
My lord, as for our instructions, my lord, initially the case was rejected in the year 2014 by the SLC on the ground of lack of vacancy. And thereafter again it was placed in the SLC held on 28/12/2020. It was rejected on the ground of NCT wrong. Now, my lord, keeping that apart, my lord, since the petitioner's husband, mother, expired on 2010, now it is 2026, my lord. So by going through the Devapura theory judgment, my lord, my learned friend has no case.
Why?
Because the very purpose of the compassionate appointment improves.
No, but that delay happened in your hands. Repeatedly, you are rejecting it. It's
Yes.
not a case that he applied late. He applied in time. DLC recommended it. SLC was rejecting it time and again.
My lord. Initially, there was no vacancy. Again, it was reconsidered. There it was that NCT norms was not fulfilled.
What
So
is that
accordingly, his case was considered and rejected.
What is that NCT norms?
That is that minimum 45% in class 12 intermediate exam is required.
But that DLC says that it is that pre-cutoff date, not required. That is his submission. If you look into
Even this honorable court also lordship observed that.
this honorable court observed on the basis of the as the submissions were rendered that this is the finding of the DLC.
Yes.
Come to page number 22, Mr. Pegu. 22, serial number 14. On the right hand column, he finds in the case prior to so and so PC criteria, or we don't know what PC criteria. Council says it is percentage criteria.
I don't maybe different, I'm not sure, but the remarks
is not there, but in the third column, this is an application for 80 so and so, but there appears to be no remarks.
whether it was recommended or not, it is also
not there. So get the record from the records, you trace out and tell us. Your affidavit does not say anything. This is what was pointed out by the court to the petitioner. He says the reference at column number 3, reflecting the date of application and for 80 LPS. According to him, this is the recommendation, but this appears to be indication of the application and for which post applied.
One more thing, my lord. My lord, I'll have to get the records because yes, in one case, my lord, his case was rejected because of that percentage, 45%. He didn't get. Next time again, he applied that date of application is different. This betterment mark sheet was submitted.
My lord, page
That means
24.
there were 2 applications.
My lord, page 24 recommendation was made, lordship. Page 24, lordship. The committee discussed and examined all aspects and recommend in respect of serial number 14 also includes. My name is 14 for the post of lower primary teacher for appointment on compensation. Page 24 of the lordship, that DLC minus.
Otherwise, also, my lord, that judgment, Devapura theory, my lord, it says, my lord, after a delay of several years, whether it is on the fault of the petitioner or the authorities, my lord, in deciding such claim, my lord.
No, but
And now, my lord, this compassionate scheme has been closed. That is there. Lordship may kindly reduce this order of the coordinate plans, my lord. There are 7.5.
see, the scheme was floated by the department.
My
People applied. There was some delay.
and all the pending cases, my lord, were considered recently, my lord, in terms of the order passed by coordinate bench in all the pending cases, my lord, which was disposed of on 3/4/2025. And after that, the department has issued notification and called for their documents, pending cases.
These are all prior. You see, except for the ground, because you will have to now support the rejections made by the SLC. SLC rejected not on the ground of Devbrat Tiwari. SLC rejected on the ground of non-availability of NCT norm, whatever. What is that norms?
Then let me get the record then.
See that. What does the norm say? Matter stands deferred after, listed after 1 week, enabling the learned council appearing for element.
Right, state.
State to obtain the required instructions with regard to the NCT norms.
I got.
Yes.
Maybe. Matter, wherein, my lord, the order passed by the educational tribunal is under challenge. The brief facts would be like the respondent number 4. She was working as an assistant teacher in the school. She was placed in the suspension, my lord. Thereafter, a departmental proceeding was initiated. She was asked many a time to participate in the departmental proceeding. She was given a show cause notice. She inspected the documents which were relied upon in the show cause notice and thereafter filed her reply. After that, my lord, she stopped appearing in the inquiry. Finally, decision was taken to go for expertise. Then thereafter, my lord, the penalty order was issued by the competent authority. Now, in the interim, my lord, the respondent number 4, she filed a petition before the educational tribunal challenging her suspension. In that proceeding, my lord, she filed an application praying for documents, my lord. After the DP was over, my lord, the education tribunal rejected that application by passing a reason order that these documents are not relevant to the proceeding. After that order, my lord, waiting for some time when the presiding officer changed, we filed another application with identical prayer with the same documents. Now, this time the presiding officer perhaps, without considering the previous order passed an order directing the petitioner to give the documents. So there are two contradictory orders of the same tribunal before your lordship. This is the brief background.
First order was passed by the education tribunal.
Same tribunal, the second order was also passed. The presiding officer changed in the meantime. So the second order by which the direction was given to give the documents, my lord, that is under challenge before your lordship. That is briefly the case. Because once it has been
You are
rejected,
representing whom?
I am representing the Uride Singh, that is the principal of the school.
Principal of the school.
Yes, ma'am.
So this matter, both the orders should be set aside, the matter be sent back to the tribunal for.
At least the second order, the interim order, that has to go because it's contradictory apparently. Second order has to go, ma'am,
Second order is to allow.
to allow the documents. So that has to go because the first order, the documents have already been disallowed.
My lord, my respectful submission here. So far, the first order was concerned. That was in rejection of my application to bring on records. Now, the reason behind the rejection on earlier count was because my requirement of calling for documents was not specific, it was vague at page number 65 of the writ petition.
I'll take your lordship to the entire facts.
So let us see the first
Yes,
order.
I'll just take. All right. The first order, my lord, will find page 65, ma'am. Annex 8.
65.
Yes.
This is a, you are challenging a proceeding against, initiated by a private school.
Absolutely, my lord. My initial grievance was against an order of suspension against which I approached this honorable court in a writ petition. This honorable court relegated the matter to the learned educational tribunal pursuant to a notification, my lord. Now, there when the the appeal before the educational tribunal was pending, during that time I was removed. I initially challenged the order of suspension. During the pendency of the appeal, I was removed. I amended the appeal and I challenged the removal order also. Now, during that proceeding, my lord, I filed an application initially asking for a direction upon the respondent, that is the principal of the school or the management of the school, to produce certain documents which would be relevant for establishing my case in appeal. Now, initially that was rejected. Subsequently, I again filed an application specifying the documents which I require. That was allowed. Against that order whereby the documents were allowed to be produced, directing the respondents to produce those documents, they came up before this honorable court in writ petition. Now, this writ petition is pending ever since, my lord, and in that process, the matter before the educational tribunal, the appeal, that is also put at halt, effectively because of the fact that without adjudication on this, we cannot proceed. And my lord, if these documents are not allowed to be called for, my appeal, well, literally, I am non-suited insofar as my appeal is concerned, because it is my appeal. I have to establish my appeal, and for that I have specified the documents which are required. Now, admissibility or non-admissibility of those documents would come at a later stage. Only after those documents are before the learned educational tribunal, they can file their objection to those to the admissibility of those documents. But at this stage, my respectful submission is let it go.
This is 65 is the first order.
65 is the first order, my lord.
Then
Then second order is page 67.
67.
Yes.
So 67 is only calling for the orders.
Yes. The specific documents.
Let call for the original minutes book, salary and attendance register, report register of KG2, school magazine, etc. as paid. These are precisely the documents, my lord, which were asked in the previous earlier one. Our contention is that, my lord, these documents are not at all relevant for the DP.
Now 665.
Yes, my lord.
The court, while rejecting the application, has also called for the original records.
Yes.
No, that's a different thing altogether. We'll produce before that we never
So
objected.
according to you, these original records do not contain these documents.
No, the problem, not what our contention is that whatever the original records is there concerning the DP, that will place before the honorable court. There is no problem with that. But here the petitioner is asking documents which were not the relied upon documents in the DP. Lordship is aware that in a departmental proceeding, you cannot ask a copy of the Constitution of India. The documents which are listed in the show cause notice, those are relevant documents. You are entitled for those documents.
Beyond these documents.
Beyond these documents. I'll just show by taking your lordship with the entire proceeding. So that is our case.
Why are you asking for these documents?
My lord, so far the relevance of these documents are concerned. My lord, here your
Matter,
lordship.
so
who
insofar
actually?
as the proceeding is concerned,
Yes.
it is at that stage of documents.
Yes.
Yes, at the stage of documents, and he is challenging this proceeding is with regard to challenge to suspension. Subsequent to that, my lord,
He was dismissed.
from service. So perhaps the suspension challenge to suspension, in my respectful submission, subject to what my learned brother says, I think hardly it survives.
The
Because-
dismissal is not under challenge.
No, it is now under challenge pursuant to the amended memo of appeal that has been accepted without objection by the other side before the education tribunal.
Because the
Now,
suspension period.
why these documents are necessary?
My lord, so far these documents are concerned, the incumbent who was placed under suspension initially, the allegation to that was her irregularity in the school, which was taken as a misconduct. Apart from those, my lord, there were allegations in regard to her insubordination to the authorities. Now, so far as these minute books are concerned and the salary attendance register concerned and the report register, these would go to show that the presence of the incumbent in the school was not could not have been taken up as an issue for placing her under suspension and eventually dismissal. And my lord, my lord, point out one thing: this school is a private school, wherein the management is headed over the headmistress happens to be the mother of the incumbent, and this the incumbent
Headmistress is the mother of the
yes.
incumbent.
Yes, and
Incumbent means
the one who is placed under suspension and eventually dismissed. And this basically is a family feud, my lord, which has resulted in all this. And there are several other litigations pending between the same parties on different counts. Now, this is one such issue wherein, my lord, the respondent number 4 herein is prejudiced in so far as her entitlement to litigate against the orders by which she has been subjected to suspension and eventual dismissal. Now, this is only at the stage of documents, as your lordship has rightly taken note of. So, my humble submission would be that whatever relevance of documents are concerned, that will be adjudicated by the learned educational tribunal. Educational tribunal, my lord, is sitting.
But the tribunal has already called for the documents.
Exactly, and thereafter, if the documents are not relevant, those documents can always be not taken note of. They can always come up with objection against those documents.
So where is your application calling for the document?
First application, your lordship, that your lordship will see at page
61.
Your application is at page
Doesn't
66.
say anything.
and then at page 66.
That
That is
66 does not 66 does not say anything.
Doesn't say anything.
no,
Why these documents are necessary? These documents are over and above. These documents are not included in the list
Exactly.
of documents furnished.
Exactly.
No, my lord, if I may be allowed to just read the only paragraph that is there. That the respondents, despite order to produce all original documents relating to suspension and termination, have not submitted original minute books.
This order was passed by whom?
This is by the educational tribunal.
Where is that order?
Page 67.
Page 65 is the first order whereby your lordship has just taken note of that the original documents.
Original record.
Yes. Now that was one thing that direction was there on 15/11/2021. We eventually filed this application on 25th April. This would be 2020, and eventually the order gets passed whereby the documents are allowed to be called for on 14/2023. Now, in between, my lord, there have been as many as 9 dates gone in the proceeding, whereby despite there also being a direction in the earlier order to produce the original record, that was never produced by the school management, that is the school authority. Now, this educational tribunal matter is, my lord, insofar as the effort of the school management is concerned, it's apparent that they are perhaps more interested in delaying the matter.
Milord, with all due respect to my learned brother, Milord, that submission is incorrect because nonetheless call for the original.
So we propose to do one thing.
My lord.
We interfere with this order,
my lord,
of 67.
Yes, my lord.
Yes.
We remand the matter back.
Yes, my lord.
We direct the tribunal to
take it
examine the matter in its entirety And upon, because it has already called for the original records.
Yes, yes.
So upon examining it, if it feels that further documents are necessary
My lord.
in terms of your
With all due
application.
respect, one small submission. The learned tribunal also, if I have not misunderstood, the learned tribunal also cannot go beyond the relied upon documents.
That you urge before the tribunal.
No, that's true, my lord, because
But if the tribunal feels that yes, these documents, supposing a document X is there, that document X refers to document X1, will you say that X
that can be. Lordship will kindly appreciate. This order is very specific. You produce the original record pertaining to the suspension and dismissal of the appellant.
That's what I want.
Milord, the documents pertaining to suspension, dismissal of the appellant, I can produce. We can produce before the learned tribunal. No problem.
That must contain
Yes.
the list of documents which you have
Exactly, Milord.
given
Those
him in the
documents
show cause notice.
we are ready to produce before the
Right.
learned tribunal. No problem. But by this order, the learned tribunal subsequent order has said you produce these, all are irrelevant.
Therefore, we will make it, we will keep it open for the tribunal to decide
Fine.
whether these documents would
Absolutely.
be necessary after hearing the people,
Absolutely.
counsel for the parties.
It will be placed before the tribunal only. Because why I'm saying so, he is asking for documents
if
which
it
is
is
not
to-
part of the DP.
No, if it is to be placed before the tribunal, there are two ways to do it. That we remand the matter back, directing the tribunal to, without interfering this order, giving liberty to the tribunal to examine whether these would be necessary for the decision
It has
which
already
are sought to be taken.
It has already been, with all due respect, Milord,
Ah.
it has already been examined by tribunal once in page 65.
We are asking you whether these documents have been called for by the tribunal as yet has been
No.
received.
No. Tribunal only said that tribunal needs the original record
That is
pertaining
the
to
first
suspension.
order. I'm talking about the
Yes.
second order.
No, Milord. After that, Milord, this order has been stayed by this honorable court.
My lord,
We'll remand it back.
yes, my lord. That would be because now, my lord, it is almost 3 years since this petition is pending.
Whatever documents the tribunal wants, Milord, we can produce, no problem, Milord, connecting to the suspension in the departmental proceeding.
What is under challenge before the tribunal?
Suspension order.
And
Suspension
subsequently the dismissal order.
That is also amended.
That appeal has been amended without objection.
Heard.
Lordship can take up, can produce give a list of documents for your Lordship's, sorry, list of dates for Lordship's assistance.
Not necessary. Why should we go into all detail?
Now, already delayed, my lord. This matter
We
needs
should go back.
Fine.
The only question is whether these documents are necessary or not. If we propose to pass an order, then the tribunal will examine the original records which are already called for.
Yes.
And thereupon, if it feels that further documents are necessary, then we'll consider his prayer in the
Fine.
application.
grateful, grateful. Great.
Third, Mr. H.K. Das, Senior Counsel, assisted by Mr. N. Keshav. And Mr. Chakravarti.
For respondent number
Chakravarti
4.
for respondent
4, my
4. Mr. P.P. Dotto for 1, 2, and 3. Huh?
Yeah, formal party, nothing private.
One of those happy matters. The petitioner before this court has assailed the order dated 14/2/2023, passed by the Education Tribunal, passed by the Court of Additional Session Judge in bracket PTC in its capacity as the Educational Tribunal in the district of Kachar, Silchar. In this case, within bracket ET, bracket close case number 08 of 21. Stop. By the said order, the tribunal on an application filed by, on a petition filed by the petitioner, dated 25th of April 2022, seeking a direction call for certain documents, directed the original minute books, salary and attendance register, report register of KG-2, school magazine, etc. was called for. Stop. The tribunal called for on an application by the respondents.
Yes, respondent number 4.
The
Hearing.
tribunal passed this order on the application filed on 25 April 2022 by the respondent.
Number 4.
Number 4.
Number 4.
Para being agreed, the present writ petition is filed, praying for setting aside of the interim order dated 14/2/2023. Stop. The learned senior counsel appearing for the writ petitioner submits that the petitioner was an employee of the so-and-so school, Emmanuel High School, Emmanuel English
High School.
English HS School, Paliapur, PS Lokhipu, Kashar. Stop. Pursuant to an order issued by the school authorities, the respondent was suspended initially, which came to be challenged before the educational tribunal by filing Miss Appeal ET 8 of 2021. Stop. By the said educational tribunal, the following order was initially passed on 15/11/2021, page 65, into order extract. Para. Yeah, I got it aligned.
One small pair,
Uh.
prior to that, this order was passed, page 67, 65 order was passed on the basis of an application at page 61. And this application of the respondent number 4. And this application contained the justifications also. Serial number 1, 2, 3, 4, 5, 6. And those were found to be unjustified, and thereafter this page 65 order was passed.
During the pendency of the appeal and the suspension order issued against the respondent number 4, proceedings were initiated and the respondent 4 was dismissed from service.
Well,
dismissed.
Is there
28/7/2021.
28/7/2020.
28/7/2021. So the submitted that the respondent number 4 thereafter filed an application seeking amendment of the appeal for incorporating necessary changes for assailing the order of dismissal as well. Stop. It is submitted by the counsel to the respondent 4 that the application seeking amendment was allowed and presently the appeal challenges both the suspension as well as the dismissal order of the respondent number 4. So, while the matter was situated thus, the petitioner, the respondent 4 filed an application dated 4th of September 2021 seeking the direction to submit, seeking a direction to the defendant therein, namely the writ petitioner herein, for submission of original registers, minute books, correspondences, representations, for my inquiry proceedings, magazines of school, resolution, etc. So, detailed particulars of the records sought for was included in the schedule appended to the application filed before the tribunal. Stop. Thereafter, the tribunal, by the order dated 15/11/2021, upon consideration, did not accede to the prayer of the respondent number 4 on the ground that cogent explanation has not been tendered by the said respondent 4 in its application before the Education Tribunal calling for the documents, and therefore petition was consequently rejected. So, nonetheless, the original records pertaining to suspension and dismissal of the appellant was called for. Extract to the same order is extracted below. Correct. Thereafter, the petitioner filed another application being dated 25th of April 2022, whereupon the order dated 14/2/2023 was passed by the tribunal, which is impugned in the present proceedings. So, the order dated 14/2/2023 reads as under extract rule, page 67. The issue before the court, the present petition is filed with two authorities, the sealing, the impugned order dated 14/2023. So it is submitted by the learned senior counsel for the school that these documents which are called for are not the documents, are documents which are totally unconnected with the documents relied upon by the school for the purposes of the disciplinary proceedings undertaken against the writ petitioner leading to his dismissal, to her dismissal. Stop. The learned counsel, senior counsel, has referred to the show cause notice dated 33, yes, 2021, submit that the show cause notice elaborately lays down the grounds for initiation of the proceedings, calling upon the respondent number 4 submit its replies, and the said show cause notice also contains a list of documents. So therefore, and copies of these documents were already furnished.
Yes. And
The-
she's inspected and filed reply also.
The writ petition to the respondent number 4. So submitted that the respondent number 4 also inspected these documents and filed his reply before the authorities concerned. So it is therefore submitted that the application dated 25 April 2022 and the consequential order dated, impugned order dated 14/2/2023 passed by the Education Tribunal on the said application was totally uncalled for, as the documents relevant for the purposes of deciding the appeal were already furnished to the petition to the respondent board, and the predecessor presiding officer of the Education Tribunal had, by the earlier order dated 15/11/21, had already rejected the claims of the writ petitioner by the said order. So it is therefore submitted that the writ petition be allowed, the impugned order dated so and so be interfered with, set aside and quashed. Mr. Chakrabarti, appearing to the respondent number 4, submits that these documents sought for by the application dated 25 April 2022. Mr. Chakrabarti submits that the subsequent application dated 25 April 2022 was filed in view of the earlier order of the tribunal dated 15/11/2021, wherein it was stated that no cogent explanation was given as to why these documents were required. Stop. He submits that the subsequent application has been furnished has been filed in view of such finding of the Education Tribunal by the earlier order dated 15/11/21. Stop. It is strenuously submitted by the learned counsel for respondent number 4 that these documents are indeed necessary for a decision, appropriate decision by the tribunal, as the headmaster or mistress of the petitioner's school is the mother of the respondent number 4, and the dispute is essentially a family feud, and therefore there are a lot of documents which would be necessary to support the case urged by the respondent 4 as the appellant before the Education Tribunal. Fair. Anything more?
Bye.
Having learned counsel, the parties have been heard, there is the courts have been produced. Readings have been produced. So the challenge before the courts is within a short compass, in as much as the only order dated 14/2/2023, which is extracted above, is under challenge. Stop. Perusal of the earlier order dated 15/11/2021, which is also extracted, this order, extracted above, reflects that the tribunal has called for the original records pertaining to suspension and dismissal of the appellant from the concerned respondents. Stop. Presently, the matter is at the stage of the records being called for and produced before the tribunal. Are issues required to be framed there?
Thereafter, the issues would be framed.
The issues before the tribunal have not yet been framed. Stop. Under such circumstances, this court is of the considered view that since the original records and documents have already been called for by the tribunal by the earlier order dated 15/11/2021, let these records be placed before the tribunal by the petitioner, and thereafter the tribunal, upon examining these documents and upon hearing the parties before the tribunal, will reconsider the application dated 15 April 2022 filed by the writ petitioner, filed by the respondent number 4, seeking additional documents. Stop. The tribunal must examine the matter from the standpoint of the documents which are from the standpoint of the school authority, disciplinary authority, in respect of the show cause notice dated so and so, and thereafter pass appropriate orders as to whether the further documents as prayed for by the respondent 4 by his application dated so and so are necessary. Stop. The matter is therefore remanded back to the tribunal to pass appropriate orders as directed in view of the directions above. Impugned order dated 14/2/2023 stands set aside, granting liberty the tribunal to pass appropriate orders if required as directed the order.
Fine.
The writ petition accordingly stands disposed in terms of the above. Relevant records, if any, called for from the tribunal to be transmitted to the tribunal forthwith.
But we'll fix a date.
The parties will appear before the tribunal on
27th August. Records are not here, my lord. So record
if any.
if any. So 27th August would be fair.
Fine.
parties will appear before the tribunal on, we'll give you a little longer date. Take a date in the first week of September.
My lord, second or 3rd of September.
All right, 2nd September.
Fine.
Deeply.
Yes, both.
Some of the portion, my lord,
Petitioner
respondent
responded.
for interchange, my lord, also will kindly check up that.
And my lord, also his and her. It's her actually, not his. Obliged. Obliged.
Deeply.
We'll have to use artificial intelligence.
The intelligence of this court is enough, my lord. Artificial is not required. Originally it's fine. Much obliged.
Yes.
Yes, my lord. The petitioners are all the working as an assistant professor in the Haflong Government College, my lord. The main point arose, my lord, they were appointed by the autonomous councils and subsequently by way of cabinet decision, their service has been regularized in 2016. Now the point arose, my lord, that whether the stopgap arrangement made by the college authority, by the autonomous council under the executive power of the college education general, whether the career advance benefit they are entitled to get it or not. They are presently working, they are getting the UC scale of pay, but the stopgap arrangement made by the autonomous council for the period, my lord, whether they are entitled for career advancement benefit. If the power is there of the autonomous council for making appointment as a stopgap arrangement under the executive power exercised by the under paragraph 6 of the 6th schedule, then my lord, we have a case, my lord. And that is the point required to be decided, my lord.
Who's for the NC Hills?
NC Hills files the PTR, my lord, affidavit. They have supported us. NC Hills, by virtue of their resolution, they have recommended it to the government. Government, by virtue of subsequently, regularized our service.
So you were appointed under 3F.
Initially, we were appointed as 3F for the first petition, my lord. Appointed subsequently, my lord, by virtue of the Honorable High Court's order, their service has been terminated, but they were allowed to continue.
Their services were terminated.
Terminated, my lord, is required to be terminated by virtue of the court's order, but they were allowed to continue as a stopgap arrangement as there is no persons working in their college, my lord, at that relevant time.
All right, then.
Then, my lord, their service subsequently their cabinet memorandum has been proposed, and despite the my lord objections of the higher education department, their service were regularized by way of cabinet decision. Now the point is they are getting the benefits. The stopgap arrangement made prior to regularization, my lord, they are not asking for any, my lord, area salary, only for career advancement benefit they are entitled, my lord.
By counting their services.
Service, my lord, only for that particular period, my lord. From 2013, my lord, they are getting the UC scale of pay, though their service were regularized by way of cabinet memorandum in 2016.
They are asking for that.
First, my lord, they are, as the my lord, higher education department contention is that as per the Assam Education Service, appointment can only be made on the recommendation of Assam Public Service Commission. So if the rules are there, whether the autonomous council can make appointment under the executive power exercised by the state under paragraph 6, that is only the point. If that is so, my lord,
you said there was a cabinet decision.
Cabinet decision
subsequently. What happened after the cabinet decision?
The service has been regularized, my lord.
By the council?
Not by the government, my lord.
By the government?
By the council wrote to the, my lord.
Where is that order?
The notification is a page, my lord, 56, my lord. Cabinet memorandum is page 56.
56.
That is the cabinet memorandum, my lord.
Cabinet memorandum. After that, what happened?
That, my lord, that is all the notes are there. Then thereafter service were regularized, my lord.
No, is there a specific order for regularization?
Yes, my
of
lord. Yes, my lord. Yes, my lord. Is 71. Annexure 6. After careful consideration and with the approval of the state cabinet, the governor of Assam is pleased to regularize the service of the following 8 numbers of contractual teachers of Haflong Government College with the scale of pay of so and so, with grade pay of so and so, plus other allowances as admissible with immediate effect. They will be guided by the new pension rule 2005 and subsequent government office memorandum thereof. Their interstate seniority will be fixed later on.
Regularized will be with immediate effect.
With immediate effect.
So regularized with effect from 27.
27 February 2016, my lord.
Right.
If their services are regularized, my lord. So, my lord, if the lordship look into the cabinet memorandum annexure 56, all the facts are there. They were appointed by the Autonomous Council. Their service, though their service were required to be terminated, they were continuing. There is no dispute on that particular fact. Now only the fact is that if they were not appointed by following the Assam Education Service rule, my lord, whether the in exercise of the power, my lord, under 6th schedule, my lord, stopgap arrangement made by the Autonomous Council are required to be taken into account for consideration only for the career advancement benefit.
Where is this career advancement scheme? Details?
The career that has not been, my lord, we have not annexed, my lord. All the it can be termed is like that way, the other service benefits, my lord. For the service benefits, not the area PN.
On 27th February 2000,
we are getting it from that day. We are getting it from that date, but from the initial date of initial appointment.
So on 27th February 2016, how many years have they put in? Till
Now
till,
that
till
my lord,
27.
10 years, my lord.
Till 27.
Till 26, they have already completed 10 years.
10
of
years.
service.
Sir.
Only for the service benefits, not for the area. Your lordship, the Autonomous Council, they have already filed the affidavit. They have already filed the affidavit. They have submitted the executive committee's resolution for regulation of the service and for the benefits also, my lord.
What is the stand of the state?
State objecting it, my lord. Higher Education Department objecting it, my lord. But we have, my lord, included the Hills Area Department. The office memorandum was issued by the Hills Area Department, my lord, regarding, my lord, entrusting the subject of college education general.
Does the office does the cabinet memorandum say anything about the services rendered in the contractual period?
My lord, my lord. The
Is
cabinet
there-
memorandum says, my lord. Is 56 is the cabinet memorandum, my lord. Your lordship, look into the first one. The Haflong Government College was established in the year 1961. It was taken over by the government in the year 1975. The Haflong Government College is the premier college of the entire Dima Hasao district. Over the years, by virtue of its quality education, it has earned a distinction of being a premium institution of the region. Until 2009, the Cotton College, Gauhati, the Difu Government College, and Haflong Government College comprised a common cadre of teaching staff. Teachers appointed in one college could get transferred to any government college. As a result of this, faculty teachers appointed in Haflong Government College got transferred to other government colleges, and the Haflong Government College faced crisis for want of teachers. To mitigate the problem, the Dima Hasao District Council appointed a number of teachers on contractual basis. A total of 18 lecturers were appointed from 2005 to 2008 in different phases by the District Council. Among 15 numbers of contractual teachers, 8 are found to be possessing UGC's qualification and are working against valid sanction post. Since the lecturers are working continuously without break and have rendered service during the period when the college faced crisis of teaching staff, the Higher Education Department proposes to regularize their services. The teachers are working against valid sanction post. The list of teachers sought to be regularized is enclosed as Annexure 1A. The 8 numbers of lecturers whose services are sought to be regularized possesses UGC qualification and have been rendering sincere services since 2005. They could not apply for direct recruitment due to the fact of age bar and for roster reservation. Hence, it is proposed to regularize their service on humanitarian consideration and on the basis of the fact that they rendered sincere services when need of teachers at Haflong Government College was badly felt. As per government letter dated 21/12/2015, the Principal Secretary NC Hills Autonomous Council Haflong has submitted an undertaking that no fresh recruitment contractual of lecturers will be made in the college in future without prior approval of the government. Views of Finance Department, Personnel Department, and the Assam Public Service Commission was sought for and is reproduced below.
What is the procedure for appointment of college teachers now in NC Hills?
While in NC Hills, my lord, the government colleges, the appointment is required to be followed by following the Assam Education Service rule, my lord, by selection of by the Assam Public Service Commission, my lord, that is the Assam Education for the recruitment of assistant profession. But as a stopgap arrangement, when the college education general is the entrusted subject of the autonomous council, whether for mitigate the hardships of the students, if the autonomous councils made the appointment and subsequent wrote to the government for regularization of the service, the East Hills Area Department is the nodal agency, and as per the circular minor notification, Hills Area Department is required to propose the for stopgap for my lord now our prayer for the service benefits of the period which were appointed by the autonomous council. If the honorable court decides that
now there is they are regularized.
They have already been regularized.
They are getting regular
scale of pay. Before
everything.
regularization, my lord, from 2013 they are getting the UC scale of pay. There is no dispute of that.
So how many years are necessary for the cash?
Gets my lord 10 years.
10 years. How many years have they completed now?
My lord, if it is from 2005, my lord, it is almost my lord 21 years. Only for that purpose, my lord,
I want to understand the benefit of cash is one time or twice in the service career.
For the initial period, my lord, career advancement scheme is there, my lord. For the after completion of the 15 years, like that, my lord, the scheme is there, my lord. But the first hurdle is, my lord, after 10 years, my lord, career advancement scheme is there. If they are, my lord,
that is what we are asking you.
Yes, ma'am.
That there are different milestones.
Yes, my lord.
To be achieved in this.
My lord.
So 10 years, 15 years, 20 years, something like that.
We are not bringing it on record, my lord. What is the benefits of that, my lord? And that can bring it on record also. What is the career advancement? What we are seeking now.
That's right.
We are not seeking the area salary, anything, my lord. Only for that purpose, my lord, we are paying. You can file it short affidavit only on that point. What is the career benefits? What is the regulation for that, my lord? Others are factual parts are clear, my lord. There is no dispute on the part, my lord.
Okay.
Regarding power of appointment also.
Yes, government, what do you say?
They are entitled for that part as because they are claiming the career advancement as per UGC's regulation 1998. They something was stipulated the UGC's regulation which was incorporated in our affidavit. Paragraph 10, running page I have not the running page. Otherwise, the affidavit was filed by one Nivedita Lokpor Exponent number 1
Yes.
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 Paragraph 10 This is the procedure.
Para 10.
Para 10 for counting of the past service for the career advancement schemes.
Para 10 is.
Para 10 of our affidavit. In WBC 609 of 2018.
609. 60. Yes. Yes, para 10.
Para 10. The deponent begs to state that the service of the petitioner governed by the rules and regulations framed by the University Grants Commission UGC. The claim made by the petitioners are governed by UGC's notification on revision of pay scale of minimum qualification for appointment of teachers in universities, colleges, and other measures for maintenance of standards 1998, Clause 8.00 of UGC Regulation 1998 deals with the counting of past service. The relevant portion is reproduced below. 8.00 counting of past service. Previous service without any break as a lecturer or equivalent in a university, college, national library, national laboratory, and other scientific organization, and so and so, so and so. And as a UGC research scientist should be counted for placement of lecturers in senior scale / selection gate, provided that 8.2.0 the qualification for the post were not lower than the qualification prescribed by the UGC for appointment as a lecturer. Then my lord may kindly come to 8.4.0 lordship. The concerned lecturer possesses the minimum qualification provided by UGC for appointment as a lecturer. 8.5.0 lordship. The post was filled in accordance with the prescribed selection procedures as laid down by the university, state government, central government, institutions, and regulation. My lord may kindly mark it. Then 8.6.0. The appointment was not ad hoc or in the leave vacancy for less than 1 year duration. Ad hoc service of more than 1 year duration can be counted provided that lordship A and B was there. Until 6 condition is there. B is irrelevant here lordship. The incumbent was appointed on the recommendation of the duly constituted selection committee. This is missing here lordship.
What is missing here?
The incumbent was appointed on recommendation of duly constituted selection committee. So lordship, the incumbent will be appointed as per the basis of the recommendation of duly constituted selection committee. Then their service period, which was ad hoc or temporary, more than 1 year can be counted for the lordship. The UGC's cash served benefit lordship.
This 8, this B
lordship.
B has to be read with 8.5.0.
8.5.0 lordship. In
So-
accordance with the prescribed selection procedures as laid down by the university, state government, procedures as laid down in the 1982 rules lordship.
This, if the cabinet of the state takes a decision,
Cabinet of the state takes a decision for adjustment lordship for a one-time measure lordship. One-time measure.
so
Adjustment,
it will
but
override the rules.
they cannot. Like that adjustment part we are not going. But the counting of the past service, they are claiming the
You are not allowing counting of the past service because of 8.5.0 and B,
loss.
right? So had it been through the APSC and all this, you would
Loss.
have allowed.
Loss.
So that is the procedure.
Loss.
Now, as a one-time measure, this procedure
One-time measure lordship.
was
One-time measure is only for the purpose of adjustment lordship, not for the giving of other benefit.
So
From
from where are you saying that?
From that day itself they are getting. Even lordship, our high courts have decided that particular issue lordship.
No, we'll decide, we'll
Loss.
look into it. What
Loss.
we want to understand is the benefit of UGC is to be granted in respect of any person who's continuing in service, except in a leave vacancy or something like that.
Lordship.
And normally it is, not normally, it is as per the prescribed selection procedure, etc., etc. Now,
Here lordship 8.60.
ordinarily the
8.60 is relevant here.
uh,
8.60 deals with the lordship ad hoc nature appointment. They claiming the past service we are seeing the ad hoc nature should be counted lordship.
ad hoc nature should be counted.
That part will be counted when their original selection lordship. Selection will be as per the procedure prescribed by the law lordship.
Correct. Ordinarily.
Lordship.
But here the cabinet has taken
Cabinet
a
has
decision.
taken a decision for lordship adjustment to them lordship, but cabinet did not say that lordship. Their past service should be counted.
No,
The cabinet
but
has
cabinet did not say that cabinet did not reject their claim on the ground that the rules and procedure prescribed have not been followed. Therefore, we cannot take a
the
decision.
cabinet decision was as a one-time measure by
Right. So
without
if-
going to the procedure prescribed by the statute. lordship.
Exactly. So if the cabinet's decision to regularize them was taken by the state as a policy decision,
Lordship.
as a one-time measure, over and above the procedure laid down, whether you like it or not, but the decision was
Cabinet
taken.
decision is not as a whole lordship. For a particular persons, they have taken a cabinet decision
That's
lordship.
right. So their appointment will have to be held to be as per the rule.
Have to be held from the date of their cabinet resolution, Lordship.
That's right.
From the date of cabinet resolution, they are getting, Lordship.
No, they are getting, but can you say that this is not as per selection procedure? The procedure
Cabinet
is
decision
different.
is not as per selection procedure. It is beyond the wisdom of the cabinet, Lordship. It is not by a selection procedure.
No, not by, but the purpose, the import of this regulation is that it is only in respect of candidates who are selected by way of procedure,
Lordship.
right?
Lordship.
Now you have to say the cabinet decision is contra procedure.
Cabinet decision is a wisdom of the, today I cannot say cabinet decision is right or wrong, but cabinet decision is on the wisdom of the cabinet.
That's
but
right.
they not as per the statute. But the claim which was claimed by the petitioner, Lordship, that should be as per the procedure prescribed by the law, Lordship. That particular issue was decided by our High Court as well as by the Supreme Court. Same point.
Let us see.
Same issue, Lordship.
Where is it?
Same issue, Lordship. Exactly same set of same similarly situated petitioner, Lordship.
If it is decided, then it is decided.
Lordship, it is decided, Lordship.
But if the cabinet has taken a decision, bypass the rules.
Here also, Lordship, the cabinet has taken the decision. They are claiming the cash benefit, Lordship. That was rejected by the Honorable our High Court on the basis of the law laid down by the various judgment of the 3F appointee as well as, Lordship, the Supreme Court, Lordship.
Have you gone through the judgment, Mr. Chukia?
My lord, I have not gone through it, my lord.
Please go through it and
Well,
tell
I'll
us.
go through it, but my point is, my lord, under the sixth schedule, my lord, when the college education general is there, that point never be considered in any case, my lord. That is required to be considered. If the power is there, my lord, regarding the college education general, whether the rules provided under the, my lord, Article 309 and the sixth schedule, my lord, what is the executive power, in exercise of that power, if the appointment is made, whether it can be termed as, my lord, illegal or it can be when it is had already been regularized by the government, my lord. The word regulation is used, my lord, in the cabinet decision. Service were regularized. When the person's service were regularized, when he is continuing for a particular period, then their service are regularized, my lord. I look into the judgment, my lord, and it can also be, my lord. That point probably there is nothing on that point regarding the power of sixth schedule, executive power, my lord, exercise of the executive power, not autonomous council power. All these points are may not be look into all those judgments, my lord. Those judgments, these points are required to be considered, my lord.
This point is basically when claiming the case promotion loss, CAS promotion loss. This point cannot be a point of determination. Case promotion is very specific on the basis of the UGC's regulations. We go by that. Beyond that, we cannot act close.
You go through it and tell us, but there's no cabinet decision here.
Here is the cabinet decision.
Here?
Here is the
in the judgment.
Same set of employees.
Where is it?
Same set of employees.
We could not find it.
Same set of
Paragraph?
Paragraph, Lordship, I will read it. Otherwise, same set of employees, Lordship. They are basically originally 3F, Lordship. After the cabinet was taken decision, Lordship. I will place it. I will go to it, Lordship. Same set of employees, Lordship. Here is the Cotton College. Here is the Cotton College, Lordship. And they are a 3F appointee. They are claiming for the counting of that particular period. Then Honorable Court, on the basis of the Supreme Court judgment, it was done, Lordship. Even Supreme Court also says that ad hoc period cannot be counted for case promotion.
There is no cabinet decision, at least in the submissions recorded by the court so far as you are concerned. There was some, they were initially working. Not selected by the commission.
I will place the affidavit also, Lordship, in that particular case, Lordship.
Right, you examine. Heard counsel for the parties. Matter be listed again.
Next Tuesday.
Huh?
Next Tuesday.
Next Tuesday. 11th.
11. After 15 August, Lordship, any day.
Why?
Ordered, Lordship, so many matters pending in the Tuesday and Thursday.
Let's try.
Let us understand, try to understand.
Lordship, we are